Yes, Mr.
My lord, with your lordship's indulgence, my lord, one matter, it's a very old matter, my lord. It may come up for admission.
For which bench?
It's bench 4,
4 by.
my lord, on 9th June, my lord.
May it please your lordship, my lord. Item, my lord, 43, my lord.
Mr. Chomoa, just a second.
My lord.
9th, okay.
Publish.
My lord,
Yes.
item 43, my lord. We have received the affidavit in opposition from the other side, my lord. We have to file a rejoinder. Will
Have
your
you
lordship?
informed the other side?
Yes.
My lord, my friend is present.
Dr. A. Chomoa, learned counsel for the petitioner, submits that an affidavit has been filed in the matter by the respondents, and accordingly prays, respond number 1, and accordingly prays that he be granted further 3 weeks' time to file a rejoinder thereto.
My
I
lord.
accepted matter registry to list this matter again after 3 weeks on a date to be fixed.
My lord, I'm deeply obliged. I'm obliged.
Mention to.
May,
Yes.
may I pray for listing open matter, my lord, for admission. Bench 4 matter, my lord. And my lord, item number 34 may not be taken up today after some time, my lord. Bagije matter, my lord, I have to obtain instruction because I have no contact since 2023.
Okay. On the prayer of Mr. J. Sharma, item number 34. Registry to list this matter again after 3 weeks on a date to be fixed. Yes. Mr. Yes, Mr. Ahmed.
My lord, item number 1,
We will complete the motion items and then we'll pass the order.
my lord.
My lord, if I may pray, my lord, I have a submission to make in terms of item number 5. Your lordship had heard the matter and had posed a query, my lord, on the last occasion whether
You had got the records also.
we have got the record, we have got a photocopy also, my lord, but we'd like to assist this court in a better way, my lord. Any date next week, my lord. Your lordship has heard the matter. Will just one more accommodation just to satisfy this court and
If Patha do it,
no, I mentioned
Mr. M. Sharma, learned counsel appearing for the petitioner, prays that he be granted further 2 weeks' time to make his submissions in the matter. Prayer is not objected to by Mr. S. Dr. Learned senior counsel appearing for the respondent bank. Also, accordingly, registry to list this matter again after 2 weeks on a date to be.
I'm grateful, my lord. My lord, I have an additional prayer in item number 50, my lord.
My lord, that matter, my lord, your lordship heard. Can
Yes.
it be?
No, I have not made it part heard earlier.
All right.
Item number?
Item number 50, my lord. All the
I
matter.
know, but I have part heard also.
Although the matter has come under the orders column, we were effectively directed to file our affidavit, my lord, Novojyoti Gas Agency. The affidavit has been prepared, my lord. It is sent for vetting.
Have you informed the other side?
We have informed the other side, my lord.
Mr. M. Sharma, learned standing counsel, Indian Oil Corporation, submits that the affidavit in the matter on behalf of the respondents represented by him is ready,
my lord,
and would be filed within
in a day or two, my lord. 2 days, my lord. 2 working days, my lord.
within a week from today.
My lord.
Accordingly, a registry to list this matter again after 3 weeks. The petition on the respondent number 1 filing its affidavit in the matter. The petitioner is at liberty to file its rejoinder, before the next date of listing, if so advised.
I'm grateful, my lord.
In respect to item number 45, lordship, we have taken consent for the counsel for the petition, lordship. We have entered appearance for a respondent of
2, 3,
ONGC.
and 4.
We are filing our affidavit during the course of that, lordship.
Have you informed the other?
Yes,
side?
yes, lordship.
Mr. K. Kalita, learned counsel for the respondent number 2, 3, and 4.
2 to 4.
That an affidavit.
2 to 4.
2, 3, and 4. 2, 3 comes in between. 2, 3, and 4. Submits that an affidavit on behalf of the respondents represented by him would be filed during the course of the day. Also, the learned counsel for the petitioner is granted further 2 weeks' time to file a rejoinder thereto, if so advised. Registry to list this matter again after 2 weeks on a date to be filed.
May it please your lordship.
Sorry.
Lordship, item number 4, my lord. My lord, may it come up on a hearing day on Tuesday or
Today it's hearing for me.
only one. My lord, it would be if my lord appraises on 9th, it's a Tuesday.
Very difficult. Mr. What
Lordship,
has serious,
Lordship, objection
serious
is there, but
objection.
I have requested him to mention it when the matter comes, Your Lordship. He
You
mentioned-
renew your prayer when the matter is
My
called.
lord, it's just only because in an online way. So if I would have been physically present, it would have been better. That is why I was praying for 9th. Or even on Monday, on June 1st.
Out after a bereavement, so
Lordship.
give him some time. Uh,
On 4th, Your
on the
Lordship.
prayer of Mr. S.
I'm not there on 4th.
SP Sharma, Learned Standing Council, APDCL, comma, registry to list this matter again,
On 6th, Your Lordship.
12th, 12/5/2026. No further adjournment shall be granted in the matter.
Much obliged, my lord.
12, it's okay with you, Mr.
Lords,
Huh?
I will manage.
Because there are some matters,
Lord.
right, just
Lords. Obliged, Your Lord.
Much obliged, my lord.
Delivery of document item number 61.
writ petition dismissed, award dated 26/3/2014, appel. Impugn order of penalty upheld. Writ petition stands dismissed. We have held that the loss of confidence. The notice under 148 set aside. Impugn order of penalty interfered with. Petitioner directed to be reinstated. However, liberty granted to the respondents to proceed against the petitioner by following the due process of law.
55.
Order dated 25/4/2026, 2024, set aside petitioner to be entitled to all pension and pensionary benefits. To record we get in like.
Item number 6.
None appears for the petitioner on call. The present writ petition has been instituted. A present contempt petition has been instituted alleging violation of the directions passed by this court-wide order dated 7/4/2025 in WPC number 1928/2025. Also, issue notice upon the sole respondent. Also, petitioner to take steps for service of notice upon the sole respondent within 3 working days from today. Also, the personal appearance of the petition of the sole respondent, comma, at this stage, comma, is dispensed with. Registry to list this matter after 4. Okay, none appears, huh? Same booster, sole respondent, order dated 23/4/2025 in WPC number 1880/2025. Urge Mr. J. Sharma, Learned Counsel for the petition. Order dated 14/2/2025 in WPC number 6835/2020. बाकी एके रहियो कॉलेज सपोर्ट लिखी दिबा दे डिस्पेंस with. Order dated 4/12/2024 in WPC number 6836/2024. Done.
10.
Order dated 4/12/2024, WPC 6433/2024.
7.
Order dated 7/4/2025 in WPC number 6831/2024. None appears for the petitioner on call. Pakigita Chuk Jay Sharma Thaife. None appears for the petitioner on order dated 7/4/2025 in WPC number 1908/2025. File was in. The 13 multiple. None appears for the petitioner on call. Order dated 2/2/2026. WPC 5621/2020. Oh, so no. Personal appearance of all the respondents, both.
Chip, I'm for respondent. UGC Lordship in this case, bill number 13.
No, this is item number 13, huh? Sudipta Bora. Yeah. You're not here as a UC. This is a contempt matter. File an impleading application, we'll implead you as contempt now. Item number 13. 13 is a contempt matter. Huh? You're not made a party.
Petitioner.
You are the petitioner. Nobody appeared this side. That's why I adjourned it.
Lordship,
Now you don't know you're a petitioner or a.
Lordship, wrongly listed.
Wrongly
Cause this Lordship.
Done. Mr. Bhuya,
My lord.
where is that annexure full copy? You have not
My
filed
lord,
an
my lord,
additional
I
affidavit.
have find it out, but due to some
On the prayer of Mr. A.R. Bhuya, learned senior counsel appearing for the petitioner, registry to list this matter again after a week. Mr. Bhuya, to comply with the petitioner to comply with the directions passed by the
Right.
court by order dated 18/5/2026 before the next date of listing.
my lord. Obliged, my lord.
Item 15 to item 21.
Hmm.
So that heard a similar matter on Tuesday. This is regarding the LPG tender issued by IOCL, where there was a provision for an ATS scheme. So what had happened in these cases was that the petitioners were awarded.
They'll issue a notice here, that's all.
But in the meantime, I am seeking some protection.
Will not give you because you have not been protected earlier.
No, but my lords will, for a moment.
The
just-
other cases, there were protection. Now you, in this case, your interim prayer was rejected. You have not gone up on appeal.
Yes.
So we'll consider, let them file their affidavit. We'll consider whatever happens and anything is there will be subject to outcome of this case.
But my case is this.
Your case is this, that is being considered by this court. Now I can't pass a final order today. I'll have to consider.
As far as my first round of writ petition is concerned, that
They
was
have now disposed of the representation by an order dated
Yes.
11/5/2026.
yes.
So this we will consider whether this is perfect or not perfect, whether you were given or not given. But your TTs which were suspended way back in 5/3/2026, this court interim direction earlier, final order, both upheld that suspension. So today we can't Today we can't do anything with that. So we'll say that the TTs of the petitioners under ATS, the operation thereof would be subject to the outcome of the present.
The difficulty here is this, that as for, I've seen the order that was passed in the other matter. In my case.
You
there
have
was a-
seen it also, you have heard it also because you appeared.
No. The one that my lords heard it on Tuesday.
Oh, that the facts are different.
The facts are different to this extent. In that case, what appears to have happened is that there was an extension of the existing contracts for 2 months up to October,
And yours is till December.
December. So in my case, the window of 4 months to comply with the RC and PESO stood reduced from 4 months to 15 days.
I'm sorry, this was considered. So let me maintain that consistency with the earlier
Now,
orders.
now for a moment in my lords, comes to page 193. That is the termination order.
Or you want to hear the interim prayer? Finally, I'll hear it. We will pass orders then. Yes.
Then in that case, my lords may issue notice.
Heard Mr. K. Talukdar, learned counsel for the petitioner. Also heard Mr. M. Sharma, learned counsel appearing for the
IOCL, my lord.
learned standing counsel, Indian Oil Corporation Limited. The petitioner hearing, the petitioners in the above noted writ petition 15 to
May I give a chart? Then it'll take-
21.
15 to 21, my
Huh?
lord.
It's a
No, no,
text.
21 for Tomote.
20
to 20.
number is na mostly. देखो ना ठीक है अरे ब्लैक के मारा ठीक है सर has assailed order dated 11/5/2026 wherein by which issued by the respondent number 1 corporation rejecting the prayer of the petitioner to accept the tanker trucks offered by him under the agreement to sale provision incorporated in the corrigendum dated 4/4/2025 issued to the NIT dated
1-3.
1/3/2025. Also, the contentions of the rival parties made in the present proceeding would require a deeper consideration. Also, issue notice returnable 3 weeks. Mr. M. Sharma,
My lord.
learned counsel, learned standing counsel IOCL accepts notice on behalf of respondent number 2 to 7. Madam, you are appearing for?
Respondent number 1.
Appearing on behalf of whom? Mr. S. He is here in the court today. Mr. S.S. Roy accepts notice on behalf of respondent number 1. Also, the cancellation of the tender trucks of the petitioner, offered under the ATS scheme shall be subject to the outcome of the present writ petition. So what I can do?
I'm good.
My lord, there was a statement which was not correct, which was made by me last week in the Helang form in Lima Akum, my lord. The second paragraph at page number 7, I had submitted that invariably, my lord, that work orders were not issued.
Oh,
That was a
that is the
mistaken
issue,
submission.
Your Lord.
That was a mistaken submission on my part, my lord.
That's
is-
why I
that is
told
part-
you,
my
and you also agreed to
Your
that.
Lordship.
Mister, you agreed to
No,
that.
Your Lordship, your Lordship, however.
Because what has happened therein that there was a work order
Lord-
given and that was told, that was the difference between this and Mr. Talukdar's.
Lord,
case.
That was a
work
mistake,
order,
Then you will have to file an application here.
my lord.
we have not obtained the certificate copy yet, Your Lords.
But still it will not be
Lords,
proper.
I will file, Your Lords.
You file an
I'll do as a
application,
lordship directs, my lord. That was a the
you
mistake,
file an application, we will do the needful.
my lord.
When? Tomorrow? By Monday?
By Monday, my lord.
Huh?
For clarification of the order, my lord.
For clarification.
I'll do that.
You
That
can
was
say
a
that this was a wrong statement.
that was a mistaken statement, my lord.
Because then what will happen is that the interim order may also have to be now
Lord,
modified. We may have to permit him to continue.
No,
Mr.
my other submissions would
File a small review petition,
Lords,
2-page review.
Lords, Lords.
We'll do the needful.
my other submissions would still be there.
No,
Except for that, my lord, that was a
Because
I should
see,
not have
the,
let the court, my lord.
the last paragraph says, any TTs which is being loaded, stop.
Yes.
Don't load further.
Lord,
That's why I asked.
No, but they were suspended from March.
No.
That fact is.
Your lordship,
But they were then again permitted to operate. They were not permitted.
no,
to-
your
No,
lordship,
no, no.
what has happened? your
That
lordship?
has not happened. That has
What
not.
has happened, your lordship? Work orders were issued, we were permitted to operate, then a suspension order was issued. When suspension, it was
Yes.
suspended, from then onwards.
From
your
March
lordship, it was not.
onwards, they have not plied their TTs, my lord, on the road.
That's,
And that
that's
work
the
order,
position.
work order would also be subject to the LOA. And the LOA, in my submission, my lord, was a contingent document. That aspect.
Nobody has taken the certified copies.
No. Since we have seen it, your lordship, therefore we didn't apply for it. your lordship.
Page 7, my lord. I apologize, my lord. I should not have made that submission, my lord. That was.
Mr. M. Sharma, so-and-so submits that though a letter of acceptance has been issued, the default occasioning on the part of the petitioner had resulted in the work orders issued to the petitioner not being executed.
Lord.
Think that'll do?
The-
Accordingly, the contract name cannot be said to have been formed. However, a line to continue. Accordingly, the contract in the matter cannot be said to have been. Okay, yeah, what is it? No, no, no. The 2745.
And two.
2745 and 2746.
A paragraph. There is no other correction required.
Your lordship, in page 4, your lordship,
Ah.
that RC dates needs to be corrected in 2745. It should be 12/1/26 instead of
27.
2745.
That should be
12/1/26 and 8/1/26 and 9/1/26.
no. The date of issue there is 2/2/26. RC issue. RC that right
But
hand
this will not
materially change
materially change.
because see that in the that letter
Lord.
it is given bracket
Lord.
from top to bottom
Lord.
it is written 2/2.
It will not materially.
Others are same. We'll correct that and you'll.
Lords.
I apologize, my lord.
No, it's okay.
My lord, that was a mistaken statement.
22, 23, same.
22, 23, list this as prayed for by the parties, list this matter again on Monday. We'll just have that correction done,
Lord.
uploaded, then pass this.
Lords. Deeply obliged.
None appears for the petition on. Registry to list this matter again after 2 weeks. Same order.
সঞ্জয় আমার কিমান এতিয়া কিমান চলি আছে এতিয়া 24 নেকি
May I please, Your Lordship? Lordship, we are appear for IRCTC as a panel council. We have not received the copy, Your Lordship.
We have served 7-8 copies to the,
ASDI office, Lordship, but we are,
it is the matter simple direction for mandamus for deciding the representation. of the-
Lordship, we take it up at 2 p.m.
Kindly have, Your Lordship.
Copy code serve kora bole gom tom. You are the standing council, notified.
I am the panel, yes, Your Lordship. I am the
It's
panel,
notified in the
notified panel
registry.
council, not the standing council, panel council, Lordship. Standing council, Mr. Anik Singh.
So there is a standing council.
There is a standing council, Mr. Anik Singh. He has also not received the copy, Your Lordship.
No idea. I have not served the copies on anyone.
We have served 8
Where? Show me.
in the office of the deputy.
Where is that acknowledgement?
It is with the,
Huh?
it is with the clerk, Your Lordship. Have
Till
you,
today. Madam, please find it out.
earlier okay kim unmute হইতো কানা নি
Of sound. Okay, it's here. Mr. M. Sahewala, learned counsel, submits that he appears for the Indian Railway Catering and Tourism Corporation Limited. That is the respondent number 226 in the present petition. So, he submits that a copy of the present petition has not been served upon him or any other counsel representing the respondent number 226. So, Mrs. M.S. Singh
Yes, sir.
is directed to serve a copy of the petition upon Mr. M. Sahewala during the course of the day. Registry to list this matter again after a week on a date to be
Your Lordship,
specified.
possible at 2 p.m. because
Not today, not possible.
2 p.m. Your Lordship.
I'm sorry, not
In
possible.
the month of July thereafter.
July,
20th.
in the month, Fusa, as prayed for by Ms. S. Singh, registry to list this matter again on
20th, if possible.
20th to 27, 2020. You get your instructions by the time.
Lordship.
2 and 4 minutes. CGC.
If possible, Your Lordship, record may be summoned till then.
First, let me be satisfied with the notice issue, then we'll do
Speak
whatever.
with them, Your Lordship.
We'll let me be satisfied.
Deeply.
আচ্ছা বা উঠে বস্তু আনমিউট হয়েছে না?
Made please. My lord, here the current petitioner is basically agrees by the fact that, my lord,
You waited till the last moment.
my lord, yes,
You
fundamentally.
knew about this much before. You have not approached this court. You waited. And now you say that they don't have the eligibility.
My lord, may I just submit, my lord,
When was the settlement order issued?
no, that is the point, my lord. They haven't yet issued any settlement order.
But the selection is comparative
Yes,
statements
they
have been
have,
prepared.
we are basically aggrieved by the fact that the process under which, my lord, the financial bid was, my lord, open by the respondent authorities without, my lord, adhering to the terms of the NIT.
This rejection of yours.
No,
occasion-
my lord, it was not rejected.
No, you were also there.
Yes, I'm also there.
The unqualified candidates had
Yes.
come in 8-5.
No, they appeared for the financial bid on 12/5, my lord. Kindly, if your lordship may come to the impugn notice at page 147, my lord. 147, down below, there is Assam Fishery Development Corporation. A notice has been invited, if your lordship sees, my lord. It says, my lord, it is hereby notified that the financial bid of technically qualified bidders for settlement of the bills invited under NIT number such and such will be opened on 12/5.
What happened after this?
Yes, after 12/5, I filed a representation at 18/5, my lord.
Oh.
Kindly come to my representation 18/5, my lord.
No, what happened after the bid
Yes, my-
opening?
Now, my lord, after, my lord, opening the financial bid, my lord, my financial bid was also open. And out of 8 number of bidders, I stood at the 7th position in the current list of these financial bid, my lord, when it was open, my lord. Now, the only grievance before this honorable court is that, my lord, the petitioner has been highlighting that of the list of these 8 bidders, there are 3 bidders who technically they are not even qualified.
No, how, their position is what in the...
They are above me, of course, my lord.
Okay, fine. Serial number 1?
I'll just take your lordship.
Where is that position after the opening of the bid?
Yeah, my lord, at page 345 is the list of all the technically qualified bidders and the rates offered by them, my lord. I am, my lord, Ratul Das. I have offered another past bid. I am Ratul Das, my lord. My lord, my lord.
Who is serial number 1?
My serial number.
Who are the persons here who are, you
Respondent.
say, don't qualify?
Yes, ma'am. Osim Hazarika is the one. Bijoy Das is another. And the third is, my lord, Madhav Chandra Das, the last person who quoted 22 lakhs, my lord.
Madhav Chandra Das.
Madhav Chandra Das on the extreme right. Then, my lord, Osim Hazarika,
So the highest bid is 25 lakh 66.
my lord.
And that is by Anjan Kumar Hazarika, no
Anjan Kumar
grievance.
Hazarika, my lord.
And next is 22 lakh 631, no grievance.
No grievance, my lord.
Then
my lord, not no grievance, my lord, because we could not find, my lord, after verifying the documents, there was no effect.
So you want to
detected.
have a roving inquiry by this?
No, my lord.
We'll issue a notice. We'll make it subject to the outcome.
My lord, but only difficulty is, my lord, subject to the outcome, my lord, we will definitely appreciate, my lord, but only difficulty is if tomorrow my friend and the department basically passes any order giving settlement to any one of the.
Actually, that will be what is the period of the settlement?
This was
7 years.
7 years, my lord.
So we'll come to
Yes,
consider.
my lord. That can be
But
made
Mr.
subject to the outcome.
H. Gauhati, learned
System,
counsel.
Lordship.
Huh?
Actually, it's a two-bit system. That is the issue.
No, it's a
Okay.
COVID system.
Okay. He wants to argue.
That is the, no. I don't want to argue. No, just,
Bit, what happened? First bit, what happened?
no.
He says, though they are not qualified.
No,
we
just I'm
submitted a
analyzing the,
representation.
analyzing.
Why did you not consider that? Where is the order disposing it of? 2 o'clock. Get that.
No, Lordship, that is not, I'm just informing that it's a two-bit system. That is the issue. I'm not on that.
That much reading we also do. If you have something more than that, tell me.
No,
We'll consider.
nothing.
I'm obliged, my lord.
It's Pura counsel for the petitioner. Also heard
Just for the
Mr.
sake of
Sharma,
saying, I'm
learned standing counsel. Who is appearing for government? You are appearing for one also.
what fishery department and FDC.
All
Standing counsel fishery department appearing for
And
fishery department. Also,
FDC Lordship. Both.
the petitioner in the present petition has assailed the
Which part?
procedure adopted by the respondent authorities in towards settlement of the Gauhati Angun
It's
Bhangamur mean Mahal Sipsagar. So, from the materials brought on record, it is evident that the financial bits of the bidders have already been opened and the petitioner is found to have been placed at serial number
I'm 7, my lord.
at serial number 7 out of the
8 bidders.
8 bidders. Also, further, and so far as the contentions made in the present writ petition is concerned, there is no allegation against the bidder whose bid value has been found to be the highest. Also, in view of the above, issue notice. Mr. Sharma accepts notice on behalf of respondent number 1, 2, 3, 4 and 4. No formal notice is to be issued, huh? Also, para. Petitioner to take steps for service of notice upon the respondent number 6 and 7 by way of speed post steps within 2 working days from today.
My lord, 5, 6 and 7, my lord.
5, 6 and 7, sorry. 5, 6 and 7. Right?
My lord.
The settlement of the fishery in question in the present writ petition would be subject to the outcome of the present.
Petition.
The settlement of so-and-so fishery shall be subject to the outcome of the present writ petition.
Man, I'm highly obliged, my lord.
Lord, actually, in this case, my lord, I appeared for respondent number 11. And in Ukalatnama, also.
Sorry, we had already heard the matter. We are not permitting your.
Then only one thing, my lord. The respondent 8 and 9, although he appeared along with the respondent number 11. But later on, I informed the respondent 8 and 9, I could not represent him because 11 is appearing. So, my lord, only one thing.
Only because we have already heard the matter. Today is only for.
Only one thing has not been pointed out. My reply, paragraph 2 and 6 may kindly be seen. And this person has no locus standi. He is the outsider.
No, on the date when she submitted an application, she was not married.
But on
That we will take care. That we will take
and when interview was held, she
that we
was
will take,
married.
that we will take care.
And
With your
yes.
appointment, we are interfering with your appointment
My-
because you had a matriculation certificate.
Yes.
You have not denied that.
My lord.
Then how could you have said you
Yes, so
misled,
two
you
certificates.
misrepresented by
Two-
saying class 9? You studied in a madrasa while the same time you were pursuing classes
Yes.
in. This is unheard of.
Paragraph 6, I am not.
Paragraph
saying
6
anything.
we have read, we are denying, we are rejecting it.
And paragraph 2 also, my lord. And
We are rejecting.
And yes. So the writ petition has no locus standi. That is maybe.
The writ petitioner has had a locus standi,
Because
but now because of her marriage, she cannot be considered for appointment.
that before interview she was married, my lord. Before interview.
3/7/2013.
Yes, before marriage.
Take us.
And Gaubara certificate obtained, my lord, after marriage. On the 2 days before the interview.
You are appearing for?
This one 11. And 8 and, my lord, 8 and 9.
Who is nobody has appeared for 8 and 9.
But actually, we will not file. We also 8 and
The
9.
names before me there was none, so we will not consider.
So, my lord,
Heard Mr. H.R. Ahmed, learned counsel for the petitioner. Also heard Ms. M. Bhattaji, learned additional senior government advocate, appearing for the respond number 1 to 4. Mr. D.K. Roy, learned standing counsel, Board of Secondary Education, appears for respond 5 and 6. Also, Mr. J. Ahmed and Mr. P. A. Ahmed, learned counsel, appears for the respond number 11. There is no appearance on behalf of the respond number 7, 8, 9. and 10.
actually, we will not file. 8
There
and
is
9.
no appearance, I said, before, today.
I am, because my name is there.
For 8, 9 and
8 and 9 also.
There was none on that day. We will not.
But Ugalatama is there.
You have filed Dukaratnama for 8, 7, 8, 9 and 10.
8, 9 and 11.
Mr. J. Ahmed appears for respond number 8,
9 and 11.
8, 9 and 11.
Those are the
So that nexus is true.
but
nexus.
But I am engaged in this case. But I am
That engaged, if you engage, you engage for all 8,
But-
9 and 11.
But PRL Ahmed is the conducting lawyer. I have known that time I am not.
Mr. Ahmed, what are you making? Either you say you are appearing, or say don't appearing, we will record Mr. P. A. Ahmed's name. For 8, 9 and 11, you mean to say.
My
Eh, Ukalatnama Sosum Karkar diya.
Sir, it is there. That's why I. This is the Ugalatama.
Was listed the regime. Yeah, Ahmed, 8, 9 and 11. Take it. So,
That is I
other
pointed,
ground-
but that is I am not servicing pointed.
another ground to conclude that there is a nexus between the allegation of the petitioner that you and the madrasa people are in that is established. We'll record that. Don't worry.
That may be, that is why I clearly mentioned.
Ah.
I am not servicing well.
You never. But Likhila Nasul, 8, 9 and 11 ko iba. None appears for the respond number 10. Also, the petition by way of instituting the present writ petition has assailed the selection and appointment of the respondent number 11 as Anganwadi worker in number 196 Mollapara Mini Anganwadi Center. Also, the petitioner has also assailed an order dated 25/5/2016 issued by the Director of Social Welfare, Assam, rejecting the claim of the petitioner with regard to the eligibility of the respondent number 11 to be appointed as an Anganwadi worker in the said Anganwadi center. Also, the facts requisite in brief for adjudication of the issues arising in the present writ petition is noticed as under 3.1. Paragraph also, the Child Development Project Officer, Bir Singh Zarua, ICDS project, issued an advertisement on 4/12/2012 inviting applications for filling up of posts of Anganwadi worker and Anganwadi helper lying vacant under his jurisdiction, lying vacant in Anganwadi centers under his jurisdiction. The said advertisement had also invited applications for the post of Anganwadi worker in 196 number Mollapara Anganwadi Center. Also, in terms of the said advertisement, a candidate to be eligible for consideration of a case for appointment against the post advertised must be of 18 years of age as of 1/1/2012 and must have studied at least till class, must have passed at least class 8 examination. Also, the petitioner and the respondent number 6 having satisfied the eligibility criteria set out, submitted respondent number 11 submitted their respective applications for being considered for appointment against the post of Anganwadi worker against number 196 Mollapara Mini Anganwadi Center, hereinafter referred to as Anganwadi Center. Also, the respondent authorities, upon scrutinizing the applications received in pursuance to the said advertisement for the post of Anganwadi worker against said Anganwadi Center, shortlisted the names of the candidates so found eligible, and accordingly, both the petitioner and the respondent number 11 were shortlisted for appearing in the selection that was required to be so held. So, the petitioner as well as the respondent number 11, along with other candidates, appeared for an interview held on 8/9/2013. Also, it is projected by the petitioner that out of the 8 candidates appearing in the selection, in the interview, 5 of them were from outside the coverage area of the Anganwadi Center, and the respondent number 11 was underage. Accordingly, it is projected that it is only the petitioner and one Sonara Begum who were eligible for having their cases considered for the said selection process. Also, contrary to the position highlighted by the petitioner hearing, the respondents proceeded to consider the cases of the persons found eligible, and on such consideration being made, the
up to 26 it is over. Up to 26 motion.
respondent number 11 was recommended for engagement as Anganwadi worker in the said Anganwadi Center. The petitioner being aggrieved with the selection and thereafter the respondent number 11 was appointed in such capacity. The petitioner being aggrieved with the selection and appointment of respondent number 11, as the Anganwadi worker in the said Anganwadi Center, approached this court by way of instituting a writ petition being WPC number 28/2014, assailing such selection and appointment of the 11. The coordinate bench of this court wide order dated 29/8/2020 proceed on noticing the issues arising in the said writ petition, proceeded to dispose of the same by granting liberty to the petitioner hearing to approach the Director, Social Welfare Department, agitating her grievance It was further provided that in the event of any such approach being made, the said authority shall deal with the matter appropriately upon hearing all the parties, including the respondent number 11 hearing, and thereafter pass appropriate orders. Also, it is projected that the petitioner had submitted all requisite particulars before the Director of Social Welfare Assam. However, it is contended that the Director of Social Welfare Assam, without considering the objections raised by the petitioner with regard to the selection and appointment of the one number 11, proceeded while order dated 14/10/2015 to reject such contentions raised by the petitioner and thereby proceeded to uphold the engagement of the respondent 11 as an Anganwadi worker in the said Anganwadi center. Also, being aggrieved, the petitioner has instituted the present petition. Mr. H.R. Ahmed, learned counsel for the petitioner, has submitted that in the advertisement dated 4/12/2012, it was clearly stipulated that the candidate intending to apply for the post of Anganwadi workers as advertised by the said advertisement should be within the age of 18 years, should be above 18 years of age as on 1/1/2012. Mr. Ahmed, by referring to the admit card issued to the petitioner, to the respondent number here 11 by the Board of Secondary Education Assam, Gauhati, has submitted that the date of birth of the petitioner therein is recorded as recorded as 1/10/1995. Accordingly, he submits that considering the cutoff date as given in the advertisement, the petitioner was ineligible to apply for the post of Anganwadi worker in pursuance to the advertisement dated 4/12/2012, inasmuch as she was below 18 years of age as on that day. Mr. Ahmed has further, in support of his such submission, has further referred to the extract of the admission register of Katulipara Nobo Jyoti, Nobo Jyoti High School, when the respondent number 11 was shown to have been admitted in the said school on 1/1/2008, and her date of birth was reflected therein as 1/10/1995. He submits that the said date of birth as reflected in the admission register is the same as recorded in the admit card of the petitioner herein. Mr. Ahmed submits that after the admission of the petitioner to the said school in class 7, she had continued, class 8, she had continued in the said school till she had appeared in her matriculation examinations in the year 2011. Mr. Ahmed submits that the respondent number 11, so to demonstrate that she was within the permissible age for applying against the post advertised, while the said advertisement dated 4/12/2012, and in her application submitted in pursuance to the said advertisement, disclosed that she had only class 9 pass qualification. He submits that the said projection was made by further projecting that the petitioner had pursued her studies in Katulipara Senior Madrasa, bracket a venture educational institution at the relevant point of time. Mr. Ahmed submits that the petitioner admittedly having appeared in her matriculation examination after studying from class 8 to 10 in Katulipara Nobo Jyoti High School, she could not have pursued a parallel course within Katulipara Senior Madrasa, which is a separate and distinct institution. Mr. Ahmed submits that the petitioner's matriculation qualification, petitioner being a matriculate, the date of birth of the petitioner as recorded in the documents issued by the Board of Secondary Education Assam would fully be the document which would be permissible to be reckoned for the purpose of determining the age of the petitioner of the respondent number 11, and no other document would be mandated to be so considered. He submits that considering the fact that the petitioner, basing on the date as disclosed in her admit card for the HSLC examination 2011, the petition admittedly was a minor on the date she had applied for being recruited against the post of Anganwadi worker in the said Anganwadi center. Mr. Ahmed accordingly submits that the said engagement of the petitioner would mandate, selection and engagement of the petitioner would mandate an interference. Mr. Ahmed has further referred to the birth certificate brought on record by the respondent number 11, wherein her date of birth is shown to have been recorded as 1/1/1994. He submits that in addition to the authority issuing the said certificate being not the competent authority insofar as a registration of the birth of the respondent number 11 is concerned, submits that the said date that the birth of the petitioner having been so recorded only on 19/11/2003, in absence of any material being brought on record with demonstrating compliance of the procedure as laid down in the Registration of Births and Deaths Act 1969 for a delayed registration of a birth or a death, the said certificate would be of no consequence and would not mandate a consideration by this court. In the above premises, Mr. Ahmed submits that the selection and engagement of the respondent number 11 would mandate an interference along with the order dated 14/10/2015. After having made the said submission, Mr. Ahmed has submitted that the selection and appointment, the selection in the present matter was held on 8/9/2013, and admittedly as on that day, the marriage of the petitioner was already solemnized with one Antaj Ali Sheikh of village Arani, Pattu, in the district of Kokrajhar. Mr. Ahmed submits that although the petitioner has been given away in marriage by her father, on 3/7/2013, the petitioner having submitted her application prior to said date and on the date of submission of her application, she being a resident within the coverage area of the Anganwadi center in question, comma, the petitioner remained eligible for having her case considered for such engagement, in spite of the fact that on the date of this interview, comma, the petitioner was already given away in marriage and had moved to a different village. Right?
My lord. My lord.
Also, per contra, Mr. J. Amit, learned, along with Mr. P. A. Amit, learned counsel for the petitioner, for the respondent number 11, submits that Punasil government of Ms. M. Bhattaji, learned additional senior government advocate appearing for the state respondents, has submitted that the respondent authorities, having considered the documents placed on record by the petitioner in support of her date of birth, had found that the date of birth of the petitioner ought to be reckoned as 1/1/1994 apostrophe D. She submits that the petition, the respondent number 11, had projected before the respondents, before the Director, Social Welfare, Assam, during the hearing held in the matter, that an error had occasioned in recording of her date of birth in her HSLC admit card as well as her certificate, and she had taken due steps for correction of the same. She had already approached the Board of Secondary Education Assam for correction of her said date of birth. Ms. Bhattaji submits that the date of birth of the petitioner as reflected in her birth certificate, comma, which is again found to have been issued by a competent authority, comma, would mandate a consideration, and accordingly the date of birth of the petitioner being recorded as 1/1/2000 1994, comma, the petitioner was found to be eligible to participate in the selection process for the post of Anganwadi worker in the said Anganwadi center in pursuance to the advertisement dated 4/12/2012. Accordingly, she submits that the selection and engagement of the respondent number 11 would not mandate an interference for this court. Similarly, the order dated 14/10/2015 passed by the Director of Social Welfare Assam would also not mandate any interference from this court. Also, Mr. J. Amit, along with Mr. P. A. Amit, learned counsel for the respondents. Respondent number 11 at the outset had submitted that the marriage of the petitioner having been solemnized 7/2013, comma, and she being so married out to were married and on her marriage she having moved out to Kokrajhar district, Kokrajhar district, comma, after P7/2013, the petitioner cannot be held to be a resident within the coverage area of the Anganwadi center in question. Accordingly, it is submitted that the petitioner would have no locus to essay the selection and engagement of the respondent number 11 as an Anganwadi worker in the Anganwadi center in question. Also, Mr. Amit further submits that the learned counsels for the respondent number 11 further submits that The father of the petitioner had filed a FIR with the Fakirganj police station on 27/4/2026 inter alia alleging therein that the respondent number 11 had participated in the selection process held after the issuance of the advertisement dated 4/12/2012 by suppressing her actual age. It is submitted that the police, on completion of the investigation in the matter, had submitted a charge sheet and the case is presently pending at the trial stage. Judgment, you have been exonerated, has been charge sheet had proceeded for trial. Full stop. He submits that the learned trial court.
He can look at stand, my lord. If he cannot challenge, he is not a resident in that area, he cannot challenge.
Oh, what happened to the criminal case?
Criminal case they filed, my lord. It is no
Pending.
pending or this one, I am not know. And this is a file for legal stand at that truth judgment. He cannot challenge, but he is outsider. He cannot challenge, question the legality and validity of other this truth judgment. My lord.
You keep it, you will require it in the appeal.
My lord.
I'll give my reasons for that. Legally, have been filed and thereafter the set case is pending at the trial stage before the trial court.
I could not know it is pending or not. I could not. Petitioner can say, my lord.
You have written here, it's trial. In your affidavit, you have written trial. Also, with regard to the date of birth of the respondent number 11, the learned counsel for the respondent number 11 submits that the respondent number 11's correct date of birth is 1/1/1994. It is submitted that the said date of birth is found to be recorded in the primary school records of the petitioner of the respondent number 11. Also, it is submitted that after completing her class 7 study, from Kothuli Para Emi Madrasa, the respondent number 11 had taken admission at Kathuli Para Senior Madrasa and had studied therein till 31/12/2010. It is submitted that the respondent number 11 thereafter took admission in Kathulipara Nabojoti High School and had passed her HSLC examination in 2011. It is, however, submitted that the date of birth in her HSLC records was recorded as 1/10/1995, erroneously in place of 1/10 data apostrophe 1/10/1994. It is projected that the respondent number 11 had approached the board authorities of the Board of Secondary Education by way of submitting an application praying for correction of her date of birth as recorded in her HSLC records. Such application was contended to have been submitted on 10/12/2013. Also, the learned counsel for the next for the respondents number 11 has further submitted that the birth certificate of the respondent number 11 available on record would also go to indicate that the date of birth of the respondent number 11 is 1/1/94 and not 1/10/1995. 1/10/11, 94 or 95 only 1/10. So, in the above premises, Mr. the learned counsel for the respondent number 11 submits that in view of the overwhelming evidences coming on, materials coming on record, which indicated the date of birth of the petitioner to be 1/1/1994 and not 1/10/1995. The
Respondent number 11.
respondent number 11. The selection and engagement of the respondent number 11 as Anganwadi worker in the said Anganwadi center would not mandate any interference. It is further submitted that the Director of Social Welfare Assam on being submits that on such materials being placed before the Director of Social Welfare Assam during the hearing held in the matter, the Director had also concluded that the date of birth of the petition is to be reckoned as 1/1/1990, and accordingly it is submitted that the same being based on records available in the present petition, this court would be pleased to uphold the order dated 14/10/2025 and permit the respondent number 11 to continue in her engagement as in the said Anganwadis. I have heard the learned counsel for the parties and also perused the materials available on record. The issue arising in the present writ petition is as to whether the respondent number 11 was eligible to submit her application for the post of Anganwadi worker in 196 number Mollapara Anganwadi Center in pursuance to the advertisement dated 4/12/2012. In the said advertisement dated 4/12/2012, it was stipulated that the age of the candidate should be 18 years as on 1/1/2000. The respondent number 11 had submitted her application, and on 17/12/2012 and had therein disclosed that she had class 9 pass qualification. The application of the respondent number 9 as brought on record by the petitioner has not been denied, not been disputed by the respondent number 11 in the affidavit filed by her. So, the petitioner in the present writ petition has brought on record the admit card issued to the petition to the respondent number 11 for appearing in her high school leaving certificate examination, 2011. In the said admit card, the date of birth of the petitioner is recorded as 1/10/1995. The petitioner had further brought on record an extract of the admission register of Kothulipara Nobojyoti High School received by the petitioner under under the provisions of the RTA Act 2005, and therein it is seen that the petitioner's date of birth was recorded as 1/10/1995. Although the respondent number 11 has contended that in her matriculation records, her date of birth was erroneously recorded as 1/10/1995, and she has approached the Board of Secondary Education of the authorities of the Board of Secondary Education for correction of the same way back in the year 2013. No material has been brought on record with regard to the decision taken by the authorities of the Board of Secondary Education Assam in this connection. Accordingly, For the purpose of the present writ petition, it has to be held that the date of birth of the petitioner, as recorded in her admit card for the HSLC examination 2011 is 1/10/1995. Also, construing the said date of birth of the petitioner, considering the date of birth of the petitioner 1/10/1995, it is found that as on 1/12/2012, the petitioner is below 18 years of age, and accordingly she is not found, and accordingly she is found to be not entitled, not eligible, apply 1/1/2012, 1/12/1, not found to be eligible to apply for the post of Anganwadi worker in the said Anganwadi center in pursuance to the advertisement dated 4/12/2012. It is to be reiterated herein, it is to be noticed herein that the admission, the extract of the admission register and the details as set out therein, along with the matriculation, the admit card of the petitioner as brought on record by the writ petition, as brought on record in the present writ petition by the petitioner, has not been disputed by the respondent number 11 in her affidavit, in her affidavit filed in the present proceedings. Having drawn the said conclusion, this court would now examine the contention raised by the learned counsel, by the respondent number 11 in the present writ petition, that she was pursuing her studies in Katulipara Senior Madrasa till 31/12/2010, and thereafter had taken admission in Katulipara Nobojati High School, from where she had appeared in her HSLC examinations in the year 2011. Also, a perusal of the extract of the admission register brought on record by the writ petitioner would reveal that the respondent number 11 had taken admission in Katulipara Nobojoti High School on 1/1/2008 and had joined this said school in class 8, Roman 8. Therein it is further demonstrated that the respondent number 6, prior to the taking of admission in the said school, was pursuing her studies in class 7 in Katulipara ME Madrasa. Also, the said disclosure with regard to the earlier school of the respondent number 11 is found to be matching with the contentions raised by the respondent number 11 in her affidavit, wherein she has made a categorical statement to the effect that she had passed class 7 from Katulipara ME Madrasa and had left the said school on 31/12/2007. The difference being that the petitioner, the respondent number 11 in her affidavit has submitted that after 31/12/2007, she had taken admission in Katulipara Senior Madrasa and had pursued her studies therein. The said position is clearly contrary to the position as coming on record from the said admission, extract of the admission register of Katulipara Nobojoti High School. The respondent number 11 could not have pursued her course of study in 2 different streams and 2 different schools at the same very period of time. So either the respondent number 11 can be held to have pursued her course of study in Kathulipara Nobo Jyoti High School or in Kathulipara Senior Madrasa. The materials coming on record would go to reveal that the respondent number 11 had actually pursued her course of study in Kathulipara Novojyoti High School from class 8 to class 10 and had appeared in the matriculation in the HSLC examination therefrom in 2011. Also, accordingly, the reliance placed by the petitioner on the documents from Kathulipara Senior Madrasa would be of no consequence and the same stands rejected. The petitioner's age is this court is of the considered view that the age of the petitioners would be the date of birth of the petitioner would be the one that is disclosed in the admit card issued to her for appearing in her HSLC examination 2008. The next, the petitioner in support of her date of birth, in support of her contention that her date of birth is 1/1/1994, has also relied upon a birth certificate, a provisional birth certificate issued by the Registrar of Birth and Death, Medor Tari State Dispensary, Dhubri. So, while the said birth certificate is also projected to have been received by the respondent number 11, in her affidavit, what is striking is that in the said birth certificate, the date of birth of the respondent number 11 is recorded as 1/1/94, but the same is found to have been registered with the said authority only on 19/11/2003. There is a clear procedure prescribed for registration, delayed registration of births and death. In the present in the affidavit filed by the respondents, number 11, no material has been brought on record to demonstrate that the the birth of the petitioner was recorded, of the respondent number 11 was recorded on 19/11/2003 by strictly following the procedure mandated in this connection under the provisions of the Registration of Birth and Death Act 1969. Accordingly, this court is of the considered view that the said birth certificate would not mandate a consideration, in the attending facts involved. This court further notices that although the petitioner as on 17/12/2012 had appeared in her matriculation exam, she had, while submitting her application, disclosed her educational qualification as class 9 pass only. Such a course of action in all probability was adopted by the respondent number 11 only to ensure that, only to facilitate reliance on the documents issued by the authorities of the Kathulipara Senior Madrasa, wherein a date of birth was recorded as 1/1/1990. Also, accordingly, this court finds that the respondent number 11 had also taken recourse to suppression of relevant fact while submitting her application in pursuance to the advertisement dated 4/12/2012. Also, In view of the above discussion, this court having found that the only reliable material basing on which the date of birth of the petition can be based being the admit card issued to the petitioner for appearing in her HSLC examination 2011, and therein her date of birth being recorded as 1/10/1995, this court finds that the petitioner, as of 1/1/2012, was below 18 years of age and accordingly ineligible for applying against the post of Anganwadi worker in pursuance to the advertisement date 4/12/2012. Accordingly, for the above reason, the engagement, the selection and engagement of the respondent number 11 as Anganwadi worker in number 196, NO division number 196 Mollapara Mini Anganwadi Center would mandate an interference, and accordingly the same stand set aside. It is directed that the setting aside of the engagement of the respondent number 11 would not also result in the respondents making recoveries for the wages that was for the honorarium that was paid to her for the period she had discharged her duties as an Anganwadi worker in said Anganwadi center. Also, having interfered with the selection and engagement of respondent number 8, this court would now examine as whether what further directions will be mandated to be. The learned counsel for the petitioner had prayed that he, being a candidate from the area, within the coverage area of the and having the requisite qualifications, would be required to be engaged against the post as advertised post of Anganwadi worker in number 196 Mollapara Mini Anganwadi Center in pursuance to the advertisement dated 4/12/2000. Also, the said submission of the learned counsel for the petitioner was appreciated by this court. However, this court finds from the materials coming on record that before the interview for the said post could be held on 8/9/2013, the petitioner was given away in marriage on the marriage of the petitioner was solemnized on 3/7/2013, and she had moved away from her village to Ariani Pattu village situated in the district of Kokrajhar. It is to be noted that the Anganwadi center in question is located within the district of Dhubri. Accordingly, the petitioner is not found to be a resident within the coverage area of the said Anganwadi center, and accordingly, no direction can be issued to the respondent authorities to consider the case of the petitioner herein for appointment against the said Angan center. Also, vacancy admittedly now having arisen in the said Anganwadi center against a post of Anganwadi worker in the said Anganwadi center. The respondent authorities are directed to fill up the said post by making engagement against the same, following the procedure as holding the field today for such engagement. Also, with the above observations and directions, the present stands disposed of. Sorry. Successful patient death.
My lord. My lord, only thing is that some occasion the lordship mentioned as in place of respondent number 11 as petitioner, my lord. That may
That will be corrected, don't worry.
obliged, my lord.
I will be there.
Lordship, may I take a liberty, Lordship, and indulgence, Lordship? Apologize for the liberty. Lordship, in item number 50, Lordship, the ISL authorities have taken adjournment, Lordship, for today, Lordship. Lordship, there is an interim order that may be extended. Lordship.
Order passed earlier to continue.
Item
till
50,
the
yes.
next date.
Much obliged, Lord.
Updated, yeah. Mr. Burwa, I'll pass it after some time. Voice is gone now. We'll pick up a few matters, then come back. We are allowing your application, don't worry. Who is the one over? Select case. Yeah.
27.
Ketaman Purilo?
May I please, Your Lordship? Earlier occasion, only Your Lordship asked me to submit my.
No, we have got it. We are a pharmacist. No issue on that. Now, you were only appointed on ad hoc basis. Right?
3 years, 3 months, my lord, it is.
Ad hoc basis, you continue for 15 years. What is the difference? It can be a case of regularization. It cannot be a case of continuous appointment. Here, the initial appointment is not in accordance with the rules.
According with rule, because my lord, it is.
So what we do is, we'll have to interfere with this. We'll not interfere with the disposal because you were found to be absent for a long period of time.
Lordship is aware, my lord, this kind of, my lord, absent is not absent.
You're not a regular employee. You are just an ad hoc. You
Once
don't work, you are schizophrenic or you are anything.
My lord,
You are only an ad hoc. You cannot be said to be a probationer, can you?
My lord, you are, Lordship was as an advocate, my lord, involved in the judgment when I have.
Oh, I have made
judgment
lot
also,
of mistakes.
Because my lord, even my lord in the temporary, my lord, he otherwise long 15 years, my lord, he served in the department, my lord. It is their style, my lord, they put it, my lord, for their abandoned precaution, my lord, 3 months, my lord. But they.
You have not asked for regularization, have you?
I am not asking at this.
So it's just temporary.
No,
They don't want. They
They regularize, my lord, by their act, my lord.
Where?
Even thereafter, they transferred me, my lord, from one place to another.
Transfer is regularization. Show me a lot.
So from one place to another place. Thereafter, my lord, they themselves, my lord, medically examined, my lord, and medical board said that, my lord, I am fit to join, my lord, and
But you are schizophrenic, that is in remission. Fine. If you are a regular employee, we would have understood. But this is a case, they say that you are, because now see, the problem with you is that you are a pharmacist, you have to dispense medicines.
Yes, sir.
They say that that may not be a very conducive thing to get you to do. You are having sympathies with you.
Subsequently, my lord, in the medical board, my lord, they found, my lord, I am eligible.
But Mr. M. Bormia.
Lordship, kindly, I may be allowed to submit, my lord, some judgment, my lord. Lordship,
Whatever judgments are, you just give it to her. Just make a mark of the number of paragraph.
Then, my lord, another, my lord, aspect is that, my lordship, kindly will look in my document, my lord, they, my lord, once themselves, my lord, departmental proceeding initiated, my lord. Lordship, this
There
case,
cannot be a departmental proceeding against you because you are not a regular employee.
my case is that, my lord, if, my lord, I am to, my lord,
And they are not casting any stigma. They say because of the continuous absence, you are not. We'll see, we'll see.
no, my lord, in the
Give me the
record,
judgments, I'll appreciate. You give me the judgments.
Lordship, page 48, Lordship, kindly will look. This is important for me, my lord. Page 48, my lord. Here, my lord, they themselves, my lord, departmental proceeding was contemplated, my lord.
This is not a department, this is just an explanation call.
Yes, my lord. But it was not reached to me, my lord. Subsequently, my lord, medical board, page 49, my lord.
I've seen it.
And medical board, my lord, found, my lord, I am almost now cured, my lord. It was, my lord.
Where you are in remission, it's called in remission.
Yes, my lord.
Heard Mr. A.M. Bormia, Learned Counsel for the petitioner. Also heard Mr. J. Chutia, Learned Standing Counsel, KAAC, and Mr. M. Bhuya, Learned Standing Counsel and Family Welfare Department. For the rest. Hearing concluded. The registry to discuss matter again on 5th. 25-6.
My lord, I beg to submit, my lord, judgment in this regard.
You
Only thing,
just, Mr. Barmia, you just write A and B there, paragraph.
and now, my lord, they are developing case before your lordship because they are treating me all along as a regular employee, my lord. Therefore, my lord, since
I got your point. What I said was tentative. We will consider everything and then only pass an order. Don't worry about it.
and final, my lord, what is that, my lord? Just for my satisfaction, my lord. They are treating me, my lord, as a regular.
I'm not CV, it's not CV. I've just kept it for
Yes,
delivery
my
of
lord.
orders. We'll
And-
consider.
Yes, my lord.
We'll consider. Don't worry, each and every point of yours.
And now, my lord, they are developing case before your lordship because always they are treating me as a regular employee, my lord. My life is destroyed, my lord. 15 years
Case of
start, my
Gill is there.
my lord.
Gill.
Kill, my lord.
Yes, Gill. You can't develop by way of affidavit.
No, lord. They are developing, my lord.
Oh, I said they can't.
Yes, yes, my lord.
You give it.
They treat regular.
25th, we'll see what to do, which side to go.
I'm giving judgment.
Mr. Chetri,
Lordship.
can you show me some observation of this court at any point of time that you have to be given 15 marks? Or your 15 years of service is to be two things, 15 marks or 15 years of service is to be. This court, I think, said reckon the 15 years of service. That's all. And can that be reckoned by the selection committee, by the respondents, in violation of their own guidelines and the guidelines or the norms laid down by the UGC?
Probably this Lordship's order 6/3/26. Lordship's order. After going through the selection committee's the minutes of the meeting, Lordship kindly have a look. Minutes of the meeting, my lord. After the Honorable Court's order, it was clearly stated in the minutes of the meeting, my lord. Page 50, Lordship.
I got it. They have given you 15 marks now.
15 marks.
That's why you become number one. But can that 15
Number
marks
two,
be
Lord.
given?
Yes.
Even if we direct, can that be given? Whether it will be in accordance with law?
My lord, only here, my lord, prior to that, my lord, 3 marks was given. My lord.
That was the maximum permissible.
Maximum permissible. Then when the record was produced before the Honorable Court, Court examined, my lord. And considering all these aspects, my lord, this earlier interim order as well as
This court in the final order had only referred by taking note of the 15 years of experience to give adequate weightage in the selection process and thereafter bring the process to its logical end. As it is a matter pursuant to advertisement with. So it did not say give him 15 marks. It said take the 15 years. And that is exactly what the government had done in terms of the UGC guidelines or the norms at page 64. Affidavit. Relevant is page 66.
I know.
And if I say that this is permissible, this will be applying across the board to all selections.
Now here,
So anybody working in a non-sanctioned post will be entitled to full marks.
here, this Lordship also aware about this the rules. Of course, not in the college, my lord, in the subject teacher. Subject teacher, my lord, the 60 marks of persons who work for more than 15 years.
Subject teacher is different.
That's true, my lord.
Here the recruitment is different. Here the recruitment
Only,
is
my lord.
UGC and the norms, guidelines laid down by the state government.
This principle has been followed, my lord, and otherwise also, my lord. Otherwise also, my lord, since all these records have been placed before this Honorable Court.
Fine. This court did not say give 15 marks. This court said reckon 15 years. That recognition can only be in terms or within the four corners of the policy. Cannot go beyond the policy. You have not challenged this. That this limitation of three marks is bad.
No, I have not challenged as because, my lord, since my
Can
challenge is,
somebody get Mr. Gogoi or Mr. Das so that we can finish this up?
since, my lord,
A Gogoi or Mr. S. Das.
since, my lord, this selection committee, my lord, by virtue of these minutes, they have come to conclusion in terms of the honorable court, sir. At that part, my lord, I do
No,
not know.
that is what I'm trying to say. Where
Lord.
is the direction of this court that you have to be given 15 marks? You are referring to page
50, my lord.
50.
And that part already been communicated to the government.
No, fine, I got it. The
Lord,
government
Lord.
that,
My lord.
whatever they did, they did.
May I read, Lord? It would be better, my lord, if the selection committee meeting for selection of candidate for the post of assistant professor in the Department of Hindi, UR, Shankardeva Mahavidyalaya, Pathali Pahar was held in the office of the principal under the chairmanship of Mr. Birendranath Bhagavati, President Governing Body, so and so, so and so.
We have seen in accordance with the committee so and so,
In-
weightage of so and so in experience marks 15 in place of 3. Now,
Yeah.
from where they are giving this 15? Where is
That's-
that power?
That
This
selection,
court never said.
the selection committee may say,
How can they go beyond the regulation, the guidelines?
my lord, since as per the guidelines, my lord, I do not know, my lord, only my submission before the honorable court.
Chetri, the problem for me is if I approve this today, that will be the law.
Then lordship will consider my case for regulation, otherwise also.
Regularization, I'll consider no problem. Show me that your first initial appointment was following an advertisement and a selection.
No,
Just
that-
show me that. I'll allow it now.
No, that, my lord, that case.
You can't have both.
No, this ad hoc appointment, my lord. This
Ad hoc appointment, whatever ad hoc appointment against a sanctioned post by following the procedure. Although the notification is of 2004, I'll apply it in your case, but I don't find your appointment
My lord,
to be in person.
some of the judgment of this honorable court, my lord, that consider the case of the petitioner, my lord, in similar way, my lord.
Mr. Gogoi, she worked for 15 years. This court at one point said that reckon her 15 years experience for her appointment.
Give the marks.
No, they does not say give the marks.
Yeah.
The marks is given by the selection committee out. Because you have a policy.
Lordship.
The selection committee cannot go beyond that.
Lordship.
So what is the way out here?
When Lordship, as per the policy, one-time exercise also is not within.
No, he'll not come in because there is no selection.
No selection. Even 17/7/2004 OM also is not coming.
Not come. Even if there was a selection, I could have
Lordship. Nothing is.
pulled that down.
Nothing is there. Lordship. Nothing is.
Because if I give concurrence to this conclusion at page 50, it will be problematic. Third paragraph,
Lordship. Page 550. See?
50.
Lordship.
Because this court never said.
That cannot be Lordship.
This court never said. You come to
Lordship. Even that also.
43.
Lordship. 43. I have seen.
That weightage 5 years, 10 years, 20 years would be as per page 64, 69, 66.
40, page 43, Lordship.
43 is the paragraph.
Election second file 40 page to 9 years. Page 9 years.
43 para 9.
Para 9.
Order dated 21/11/2020.
Lordship, I have seen. Good Gauhati. I have seen, Lordship. That cannot be, Lordship. Only my lord has indicated that Lordship adequate weightage in the selection process, Lordship.
That weightage would be read
Lord.
in the context of the
Lordship,
guidelines.
Lordship.
Yes, Mr. Chhatri.
Lordship, these are
Yes,
the.
Mr. Chhatri, I
Yes.
can understand this lady's plight. But the problem is if I give a seal of approval to that, then all those selections that have taken place, wherein people from the working in a non-sanctioned post was also there, who may have missed out for 1 or 2 marks, now they all will have to be given the marks. And then a review has to take place. It will create a chaos.
Probably I have to check, my lord, regarding this additional marks. Anywhere it is there or
Not
not.
there. Don't worry about it. It's not there.
Otherwise, also in some of
This
the.
is the circular.
Then
This
Lordship,
is the circular guidelines.
Lordship.
This is again. You have a TET qualification?
Yes.
TET.
Mhm.
MPhil.
MPhil,
PhD.
MPhil plus the state eligibility test is I have already passed. Now she is 44 years, my lord, it would be out of the employment, my lord, forever.
Where did you obtain your MPhil from?
This is the MPhil from Gauhati University itself. Gauhati University itself, my lord.
You have slept.
Yes.
Qualified.
There is no problem, Lordship, but she has to, Lordship, otherwise she has to qualify, Lordship. So many candidates are
Eligibility is there. Eligibility is there.
Eligibility, Lordship, we have not taken issue. Eligibility, even
So her
Lordship,
MPhil degree will be of no consequence because she has slept.
slate. Even Lordship, all the 7 candidates have the net and slate, Lordship. All the
What
7
happened to that selection process? It is still hanging.
No, Lordship. it is-
Gone. Cancel. The post not filled up thereafter. Mr. Chatri, this post has not been filled up thereafter.
Not been.
Any interim order?
Yes. For 2025, my lord.
No coercive steps. Okay, fine.
Regarding she is working as a nursing non part-time teacher, that's why it was given, Lordship. Otherwise, she was working as a part-time teacher there, Lordship.
Non-sanctioned.
Non-sanctioned post.
Non-sanctioned. My lord,
What are the decisions you want to rely?
my lord, one decisions of this honorable court, my lord, Honorable Justice U. Bhuiya, my lord. 2016, 5/16, my lord. Lordship kindly hearing. This month.
DLT.
DLT. Seventeen, 16, 17, 18, my lord. Here is in the case also, without having the approval of the director, the selection was done. And subsequently it was.
That's a different thing altogether.
And now Lordship kindly have a look, my lord. It is 18, my lord. Just I'm reading, my lord. The rule 5.7, it is stated, my lord. As stated already noticed above, the power conduct selection and make recommendation is vested with the governing body of the college. Governing body of the college had the knowledge that the sanctioned post of lecturer in economics would fall vacant on so and so 2012 on supervision of the incumbent. The 2005 Act and the rules framed thereunder nowhere prohibits initiation of recruitment process at a date prior to the post falling vacant and no approval of the director is mandated. The selection committee had selected the petitioner and it had recommended recommended of the governing body. Director had not raised objection regarding validity of the selection or ineligibility of the petitioner. Objection of the director is that petitioner was appointed against non-sanctioned post and therefore she could not have been adjusted against a sanctioned vacancy which occurred subsequently. In the considered opinion of the court, such objection raised by the director does not stand to reason at all. As already noticed in above under the 2005 Act, the selection and recommendation has to be made by the governing body of the college to the director who shall issue orders of appointment. One possible interpretation of the aforesaid expression as appearing in Rule 5.7 would be that director has no discretion other than to issue orders of the appointment based on the recommendation of the governing body. Though such an interpretation would appear to be rather inflexible, such a view cannot altogether be ruled out as it is plausible view. However, one thing is certain, which is that under the Act, under 2005 Act and the rules framed thereunder, director is not vested with the power to grant or withhold approval for issuance of the advertisement by the college governing body to make direct recruitment to the post of lecturer. A more flexible interpretation of the aforesaid expression would be that director can either issue orders of appointment or on acceptance of the recommendation or refuse to issue orders of appointment if he doesn't accept the recommendation of the governing body, but he certainly cannot direct the governing body to issue advertisement afresh. In such circumstances, court is of the view that Director Higher Education is required to reconsider the recommendation of the governing body dated 5/11/2011 for appointment the petitioner against the sanctioned vacancy, which is now available. Consequently, the action of the governing body in abruptly terminating service of the petitioner on so and so, that too without issuing any notice to her, and whence court was in session of the matter, cannot sustain, and the same is accordingly set aside and passed. Having regard to the discussion made above, Director of Higher Education is directed to take a decision on the recommendation of the governing body of the college dated so and so in the light of the vacancy occurring in the sanctioned vacancy on 31/10/2012 in terms of Rule 5.7 and Rule 7 of the Assam College Employees Rules 2010 within a period of 4 weeks from the date of receipt so and so. Well, this is, and the petitioner would be entitled to all
This is
consequences.
basically on the question as to whether the director has a power to issue an advertisement, direct to issue an advertisement.
Yes.
But subsequently, that has been watered down a great, because now the procedure that has been worked out requires the post to be sent to the director for his approval. Then the post can be put up for recruitment, be that as it may. Because this is of 16 and your thing happened
And my lord,
sometime thereafter. One.
my lord,
Two,
2000.
another thing you see here in para 3, the non-sanctioned post against the non-sanctioned post, the appointment was by following a due process of selection.
Marathi.
Other two also is regularization.
Other two also regulation.
You have not prayed for regularization in the
There is
present
a,
resolution.
there is a prayer, my lord. Lordship, kindly have a look, my lord, my documents, my lord.
The prayer for regularization.
Yes. Lordship, kindly have a look, Annexure C, my lord.
No, in the prayer portion. You have only said that the recommendation of the selection committee is to be implemented.
Yes.
Now, can we pass a mandamus in violation of the regulations holding the field?
Let us, since in earlier occasion, when the writ petition was filed in earlier occasion, my lord, this regulation part was there, my lord. And now only as because this recommendation has been made by the selection committee, my lord, That is why, my lord, this regulation.
Only show me the power. Here, the selection committee does not have a power of its own. Because it is bound by those. It is bound by those regulations and the guidelines. So they'll have to make the selection within that parameter. It's not made. Some manner they could have done it in a better manner, not referring to an earlier principle, some letter. They could have said this and then they could have closed it. Away to that.
Now only Lordship will come to the my annexure A, my lord. This is my appointment order, my lord. Appointment order, and B is, Lordship, kindly have a look, my lord. My particular was submitted in 2006 itself, my lord. My lord, Lordship will find in annexure B, next page, my lord, page 30, serial number 7, my lord. Gitali Das, Hindi, and my lord, this government concurrence letter number so and so dated.
That is for the post.
That is for the post, my lord. And since some of the teachers here, my lord, they have been regularized, my lord. And subsequently, my lord, this annexure C, my lord, this letter was written to the director, my lord. And they say it is still pending. It has not been considered by the authority. This letter was written by the principal of the college, my lord. With due respect, I would like to state that the following few lines for your kind perusal, that sir, Shankardeva Mahavidyalaya was brought under deficit system in the year 1988. At that time, only one lecturer was sanctioned, post was sanctioned in the Department of Hindi, in which Miss Lakshmi Devi had been serving. But unfortunately, she died on 19/6/2014 because she was suffering from cancer since long, my lord. And so this petitioner look after all the affairs of the college, my lord. Since then, aforesaid post is lying vacant, although Gitali Das has been serving in the said department against a non-sanctioned post. It is for your kind information that necessary particulars were submitted in our office on 22/2006 for the regulation of our post. The copy of that letter is enclosed herewith, together with your personal application for the regulation of her post. This is for your information, necessary action. Thereafter, my lord, this is annexure D. This is the certificate issued by the principal saying that her, she is working so and so is well known to me. She was appointed as a lecturer against the non-sanctioned post in ad hoc basis in the department so and so 2005. Since then, she has been discharging her duty regularly and satisfactorily up till now. This is 19 later. Then the petitioner, another letter was submitted in annexure E to the chairman, my lord. This letter is also reflected in the Honorable Court's order. Regarding regulation of service, Gitali Bordoloi Das, Assistant Professor of Hindi Department so and so. With reference to the subject cited above, I have the honor to inform that I have been serving as Assistant Professor of Hindi Department so and so, Shankardeva Mahavidyalaya since 25/8/2005. As per the approval of GB's resolution number 2 dated 25/8/2005. There is a resolution of the GB. It's not backdoor entry, my lord. In this connection, it is submitted for your kind attention that as per the direction of the Director, Higher Education Assam, kindly for Gauhati, white letter number so and so, 13/1/2006. Accordingly, my particulars had been submitted by the college authority to the office of the DHE Assam, white letter number 22/2006, for taking necessary steps for regulation of my service. Further, I have also discharging as a caretaker officer of NCC girls of this college for many years. That, sir, I have all the requisite education qualification, experience, and also sacrificing last 15 years of valuable time of my life for this college, expecting that my service will be regularized in due course. In view of the facts stated, Your Honor is cordially requested to do needful for taking necessary action for regulation of my service on humanitarian ground. This is, now it is up to your lordship's,
No, but you don't have any prayer here.
lordship.
In the present writ petition, there is no prayer for regularizing.
No, prayer for regulation, my
It's
lord,
better you keep that thing away, because if you make that prayer, I'll have to make an observation that your initial appointment is not in person's selection. So that benefit will not come, and you're not working against any sanctioned post.
Then lordship, for a moment, if we hold that lordship, his initial appointment is 2005 as per the procedure laid down by the that relevant point of time. Then also she is not come within the considered term, lordship. As per our High Court's full bench judgment, division bench judgment, lordship, and so many single bench judgment, lordship.
no, that part,
That is in relation to 2004.
17/7, 2004, when
That,
those persons who are
that part, my
appointed.
lord, already in the judgment, it has been reflected.
which judgment?
In the this 2022 1 GLR 302 into the slab.
Rafiqul Islam.
Yes, one Rafiqul Islam and another is
Inumuni Gogoi.
yes.
All the lordship,
Inumuni
all both those judgments not considered the division bench judgment and full bench judgment, lordship, where specifically categorically stated that even lordship that Wasim Arif case, it's gone to the Supreme Court also, lordship.
Already in trouble. Why?
Lordship.
We are not going into the aspect that may cause prejudice to Mr. He is at liberty to take whatever steps he wants to take.
I have no issue.
Mr. Chetri, don't take me into that. We'll keep that issue open for you. Regularization, subject to law, you can approach the authorities. If not, you come back to this. I'm not foreclosing, I'm only with the selection process. I just feel that this being given a seal of approval will create a chaos. We don't want that, because then it will be free for all. One governing body will go to north, another will go to east, another will go to west, another one will go to south, and one may even go to northeast, southwest. So we'll not.
They will allot the
Guidelines
marks.
are guidelines.
They will allot the marks in
And
their
this
own
is,
choice candidate,
again,
lordship.
following the UGC prescriptions. It's not something which is just. Yes, Mr. Gogoi, only on this point.
That cannot be, lordship. If that be the position, lordship, that governing body tomorrow, lordship, if they like any candidates, they give any marks to him, lordship, to come to the comfort zone, lordship. That cannot be, lordship.
No,
We'll keep the regularization
that cannot
prayer.
be, lordship. That cannot be.
Heard Mr. B. Chetri, Learned Counsel for the petitioner. Also heard Mr. Das or Mr. Gogoi?
Das name be recorded. He
Mr. S. Das,
Yes.
Learned. Standing Counsel. Standing Counsel, Higher Education Department, appearing for the respond number 1 and 2. None has appeared for Inspector of Schools 3, 4, and 5. So, Mr. Chetri, please have a seat. The petitioner in the present petition has raised a grievance, has essayed a speaking order dated 19/8/2024, right?
(25/8/2000) was appointed.
Where is that impugned order, Mr.
There is no such impugned order, no rejection. 54 is earlier on the basis of earlier letter.
Now you come to your prayer.
Lordship.
Where do I get this 19/8/2024? I saw it yesterday somewhere. 19/8, no? Has presented a challenge to a speaking order dated 19/8/2024 issued by the Director, Higher Education Assam, wherein it was held that the petitioner was given the full weightage of 3 marks out of the 3 marks earmarked for teaching experience as per the guidelines in force. Also, the petitioner has further prayed for a direction upon the Director of Higher Education to grant approval to the recommendations made in favor of the petitioner by the selection committee as well as the governing body of Shankardev Mahavidyalaya, Lakhimpur, for her appointment against the post of as assistant professor in the department, right?
Yes.
Also, the facts in brief is that the petitioner herein, on the basis of a necessity arising in the Shankardev Mahavidyalaya, was appointed as a assistant professor Hindi (Hindi) against a non-sanctioned post by the principal of the institution wide issuance of a communication dated 25/8/2005. The petitioner projects that Mr. Chetri, please have a seat. I find it very.
I'm sorry.
Why should you be keeping standing? It's not required. You relax. The petitioner further projects that on her such appointment in the school, in the college, in the institution, she was also entrusted the duties of a NCC caretaker officer of the NCC girls unit of the said institution. Also, the petitioner has contended that basing on the directions issued in this connection by the Director of Higher Education Assam, the names of the petitioner and other persons working against non-sanctioned posts were forwarded to the Directorate for the purpose of considering their cases for regularization against sanctioned vacant posts. It is projected that in the department, a post of assistant professor Hindi fell vacant on the incumbent therein unfortunately passing away on 19/6/2014. Also, the Director of Higher Education Assam, having directed the college authorities to advertise the said post and conduct a recruitment against the same, the college authorities, the authorities of the college, institution college, issued an advertisement on 26/7/2019 inviting application for filling up of a post of assistant professor in Hindi. Also, the said advertisement was published in the newspapers on 6/8/2019. The petitioner being eligible for being considered, eligible for having satisfied the eligibility criteria as mandated, had submitted her application for appearing in the said selection process. Also, As the said selection process was underway, the petitioner had approached this court by way of instituting a writ petition being WPC number 7667/2019. So, the petitioner thereafter filed an interlocutory application being IA(C) number 3348/2019 in the said writ petition, praying for a direction upon the selection committee to reckon the 15 years experience garnered by the petitioner in the college against a college while making selection for the post of assistant professor in Hindi as advertised. This court, the coordinate bench of this court, while order dated 21/10/2019, disposed of the said interlocutory application by directing the respondent authorities to take into consideration the long 15 years of experience in service gathered by the applicant, that is the writ petitioner hearing, at the time of selection for the post of assistant professor in said college. Also, the said direction on being received by the college authorities, a communication dated 6/1/2020 came to be issued to the Director of Higher Education Assam, wherein it was projected that the selection committee had selected one Pooja Borua for appointment against the post of assistant professor in Hindi as advertised on merit basis, but just after the completion of the selection process, the copy of the order dated 21/10/2019 passed in IA(C) number 3348/2019 was received by the college authorities. Also, the writ petition being WPC number 7667/2019 was thereafter taken up for final consideration, and this according to bench of this court wide order dated 21/11/2023, noticing the directions passed in the connected interlocutory application, as well as the contentions made in the said communication dated 6/1/2020, proceeded to dispose of the said writ petition by remanding back the matter to the selection committee of the college to comply with a direction to comply the directions remanded back to the selection committee of the college to comply with the directions contained in the order dated 21/10/2019 in IA(C) numbers. In WPC number so and so. And upon taking, and with further observation that upon taking note of the 15 years of experience of the petitioner to give adequate weightage in the selection process, and thereafter to bring it to its logical end. Also, it is seen that the selection committee, in terms of the directions issued to it by the governing body of the college, had again considered the issue, and in its meeting held on 13/5/2024, towards compliance of the directions passed by this court in WPC number 7667/2019, proceeded to award 15 marks in place of 3 marks awarded earlier to the petitioner. In the selection committee minutes, it was observed, it was indicated that the 3 marks awarded to the petitioner earlier was so awarded as per UGC norms and the Director of Higher Education's guidelines. Also, they said recommendation made by the selection committee was accepted by the governing body in its meeting held on 13/5/2024, and the matter was forwarded to the Director of Higher Education. So it is in the above background that the Director had issued the impugned speaking order dated 19/8/2024, holding that the petitioner was entitled only to, was given full weightage of 3 marks for the experience criteria, which the petitioner contents was so issued without taking into consideration the subsequent developments taking place in the matter, including the recommendations made by the selection committee in its meeting held on 13/5/2024, which was approved by the governing body of the college. Also, being aggrieved, the petitioner has instituted the present writ petition. Mr. B. Chetri, learned counsel appearing for the petitioner, by reiterating the facts noticed herein above, has submitted that this court in the earlier round of litigation had not committed any error in directing the respondent authorities to give due weightage to the selection, to the teaching experience garnered by the petitioner. He submits that by the time the advertisement was so issued, the petitioner had garnered 15 years of teaching experience as an assistant professor, bracketed Hindi, against a non-sanctioned post in the college. He submits that the petitioner's said experience, having been directed by this court to be so reckoned by the selection committee. The selection committee in its meeting held on 13/5/2024, having reckoned the 15 years of teaching experience garnered by the petitioner and having granted 15 marks to her for the same, the said resolution, the said decision of the selection committee having been accepted by the governing body of the college, following the provisions of the Act to Urban Assam College Employees Provincialization Act 2005 and the Rules 2010, the Director Elementary Education was required to grant approval to the same, and the Director Higher Education had no authority to question such decisions arrived at by the selection committee after it was approved by the governing body of the college. Mr. Chetri submits that although in the selection committee earlier had selected one Pooja Borua for the said post, the said selection was not taken to its logical conclusion, and the governing body, after the disposal of WPC number so and so 766/7/2019, having required the selection committee to re-examine the matter, and the selection committee on such re-examination having now recommended the petitioner, the said recommendation made in favor of the petitioner would be required to be taken to its logical conclusion. And accordingly, he submits that this court would direct the respondent, the Director of Higher Education Assam, to issue consequential orders appointing the petitioner against the post of Assistant Professor Hindi as advertised in the Mr. Chetri submits that in the event this court is not in the event this court is of the considered view that the prayer made by the petitioner in the present writ petition would not, cannot be, that the prayer made in the petitioner cannot be granted, comma, he submits that the petitioner not having made a prayer for regular consideration of a case for regularization of her services, comma, the directions that would be passed by this court in the present case should not prejudice the case of the petitioner, should not prejudice the claim of the petitioner for regularization of her services, for which he submits that he would initiate appropriate proceedings. That will do, Mr. Per contra, Mr. S. Das, Learned Counsel for the respondent. The Director, Learned Standing Counsel, Director of Higher Education, Assam, submits that the recruitment to the post of assistant professor is governed by the UGC norms as well as the guidelines laid down in this connection by the government. He submits that during the period when the advertisement in question was issued by the college authorities, the guidelines as notified by the office memorandum dated 8/11/2018 was holding the field. Mr. Das submits that in terms of the set guidelines, 3 marks is earmarked for the teaching experience in the concerned subject/domain. Mr. Das submits that although this court in the proceedings of WPC number 7667 2019 had directed the respondent authorities to conclude the selection process after granting adequate weightage to the 15 years of experience gathered by the petitioner as an assistant professor in the college, comma, he submits that the set direction has to be read in the light of the guidelines. Mr. Das submits that the marks having been earmarked, comma, the consideration of the teaching experience of the petitioner for 15 years would not mandate grant of further additional marks in the matter, inasmuch as there is no provision in the guidelines for providing such marks. He submits that the teaching experience garnered by a candidate, the maximum permissible marks to be granted would be only 3 and no marks above that would be permissible. He submits that the governing body of the college, in pursuance to the directions passed in this matter, the governing body of the college on a misinterpretation of the directions passed by this court in the proceedings of WPC number 7667 2019, proceeded to allot 15 marks to the petitioner. By drawing the attention of this court to the minutes of the selection committee meeting dated 13/5/2024, he submits that while the selection committee had allotted 15 marks to the petitioner, it had made a stipulation. It had clarified therein that earlier only 3 marks were given as per UGC and the UGC norms and the guidelines of the Director of Higher Education. So, accordingly, it is seen that the 15 marks granted was not so granted basing on some established procedure, but was so granted on account of a misinterpretation of the directions passed by this court. In the above premises, Mr. Das submits that the claim made by the petitioner in the present writ petition would not mandate an acceptance. I've heard the learned counsel for the parties and also perused the materials available on record. As noticed herein above, after the advertisement was so issued, the petitioner had approached this court by way of instituting a writ petition being WPC number 7667/2019. An interlocutory application being IA bracketed C number 3348/2019 was also instituted. This court, while order dated 21/10/2019, had disposed of the said interlocutory application by making the following direction. Page 36, A to A. It is seen that the selection committee as constituted in the matter had already, before passing of the directions in the said interlocutory application by this court, completed the selection process and had selected one Pooja Borua. It was after the conclusion of the said selection process that the copy of the said order dated 21/10/2019 was received by the college authorities. Also, the college authorities accordingly, via a communication dated 6/1/2020, apprised the matter to the Director of Higher Education Assam and was waiting for his further approval in the matter, for further guidance in the matter. Also, a coordinate bench of this court as consented to by the Learned Council for the parties proceeded to take up WPC number 7667/2019 for final consideration. The coordinate bench, wide order dated 21/11/2023, noticing the directions passed, wide order dated 21/10/2019 in IA bracketed C number 3348/2019, as well as the contentions raised by the college authorities in the said communication dated 6/1/2020, proceeded to dispose of the said writ petition with the following observations and directions. Para 742 B2. A perusal of the said observations and directions made by the coordinate bench of this court in the said or judgment and order dated 21/11/2003 would reveal that the college authorities, having been found to have not reckoned the 15 years of experience of the teacher in the selection process, which was evident from the communication dated 6/1/2020, this court proceeded to remand back the matter to the selection committee to comply with the directions contained in the order dated 21/10/2019 passed in IA bracketed C number so and so, and take note of the 15 years of experience of the petitioner by giving adequate weightage in the selection process and thereafter to bring the process to its logical end. The petitioner would contend that the said directions passed by this court would mean that the petitioner has to be given 1 mark for each completed year of teaching as marks for teaching experience. While Mr. S. Das, Learned Standing Counsel, Director of Department of Higher Education Assam, would contend that the mark for teaching experience having already been set out in the office memorandum dated 8/11/2018, no marks in excess of that would be permissible to be so awarded by the selection committee. Pass the orders in the second half, 2 o'clock. Need not be here. I'll pass. Anything?
No, sir. That's I indicate otherwise also total marks is 100 Lordship. If we go by this 113 Lordship.
I'll keep that regularization open for another day. Because Mr. Chetri is here, I don't want to foreclose everything. But if I have to consider, I'll have to make observations, it may go against it. Keep it open. Another round of litigation with Mr. Das Kimandilu. Eileen.
Letter for your lordship's consideration, my lord. I have got one judgment, my lord. My lord, since the select list has not been challenged by anybody else, Supreme Court says that no, it cannot be. Whatever the discrepancies are there. 20 para lordship, the relevant portion. And this is a special case otherwise, my lord. Let there be not a precedent. Already I have been authorized now, 44 years, my lord.
The matter was listed today for delivery of orders. Also, Mr. Chetri, delivery of orders in Nadu. No, any. Mr. B. Chetri, learned counsel for the petitioner, has made his submissions. Mr. Chetri, in support of his submissions, has placed reliance on the Honorable Supreme Court in case of Srinivas K. Gowda versus Karnataka Institute of Medical Sciences and also heard Mr. S. Das. Hearing concluded, registry to list this matter again on Wednesday for delivery of orders. I'll pass the order. I'll have to go through this once. There is something here we'll have to just see.
I'll also go through.
We'll just see it. Item number kimana asil? We'll pass the orders on this. If possible, I'll pass it only.
Lordship also consider that she is authorized, my lord. That part.
That I'll give you the relaxation in the regularization part. That much I'll give you. So, Marikene, my slip quit.
Otherwise, she's not changing lordship's view, my lord. Lordship is not changing the lordship's view.
No, I'm not. I'm always open till the last moment.
Yes, sir.
I'll read this.
Yes.
Without reading this,
Lordship,
I should not come to a conclusion. There is a decision of the Supreme Court place. I will have to appreciate that. Otherwise, I would have concluded now only. Let me also see. Do you remember? We have to raise at 3:15 today. I still have 2 matters to go. Dictate. Don't know. If there is any matter wherein interim orders are to be extended, kindly make a mention so that we can take care of that. Otherwise, after delivering these 2 orders, I don't think so I'll have time. But item number 2 day. The D. Borua, learned counsel for the petitioner. So heard as thus learned standing counsel, Department of Higher Education. The petitioner in the present proceedings has presented a challenge to an order dated 11/10/2023, by which he was held to be ineligible for being authorized. The first financial upgradation under the modified assured carrier progression scheme notified by the respondent authorities by a notification dated 6/7/2017. The facts in brief requisite for adjudication of the issues arising in the present petition is noticed as under. Also, the father of the petitioner Chitan Doctor, while serving as an employee in the Jorhat Science College, had died in harness in the year 2003. The petitioner, proximate to the time of death of his, submitted an for consideration of his case on or appointment on. The said application was accordingly processed by the jurisdictional and thereafter the same was the state level committee. The state level committee on consideration of the case of the petitioner proceeded to recommend his case for appointment on compassionate grounds against a grateful post, in its meeting held on 16/10/2009. In terms of the said decision of the recommendation of the state level committee, the government in the education higher department by communication dated 3/12/2009 directed the principal Jorhat Science College to appoint the petitioner against a grateful vacant post of 2003 available in the said college. Also, accordingly, the principal Science College, Jorhat Science College, wide order dated 10/3/2010, proceeded to appoint the petitioner as a grateful employee temporarily on compassionate grounds, along with authorization to him a scale of pay and other allowances as admissible under the rules. A development had taken place at this juncture thereafter when the Jorhat Science College was merged with the Jorhat Institute of Science and Technology, Jorhat. Also, the authorities in the government of Assam Education Higher Department wide a notification dated 9/6/2010, proceeded to transfer, all existing posts with incumbents of Jorhat Science College to Jorhat Institute of Science and Technology with immediate effect. It was stipulated in the said notification that such transfer was without prejudice to the existing service conditions of the employees concerned. Accordingly, the petitioner's services now came to be placed under the Jorhat Institute of Science and Technology bracketed hereinafter referred to as just for the sake of brevity. The petitioner continued to render his services in Jorhat Institute of in just thereafter. The respondent authorities, basing on a policy decision arrived at in this, proceeded wide notification dated 30/12/2016 to declare that the administrative control of GIST was brought under the government of Assam from a higher education technical department immediate effect. It was further stipulated that the college would now function as a full-fledged government engineering college. Also, it was also stipulated that the affairs of the college henceforth be conducted as per the Act/Rules/Procedures of the government of Assam. The para, subpara, subpara good is it? The state government of Assam thereafter notified the modified assured carrier progression scheme by notification dated 6/7/2007. The said scheme was applicable in respect of regular state government employees, and it was further stipulated that the ad hoc employees, casual employees, contractual employees, work charge employees, muster rule employees would stand excluded from its coverage. So, the authorities in the Directorate of Technical Education, FUSA, thereafter, the Director of Technical Education, Assam, constituted a committee for examining the cases of the employees of falling under the directorate for extension to the financial upgradation benefits under the said MACP scheme. So, on such consideration being made, in respect of the employees of including the petitioner hearing, he being found to be so eligible for being extended with his first financial upgradation benefit, void an order dated 27/9/2020, the petitioner was extended with the benefits of first financial upgradation under the said scheme. The petitioner received the benefits under the said scheme. However, subsequently, by the order dated 18/1/2020, the extension of benefits under the financial upgradations of benefit of financial upgradation under the MACPS scheme was kept in abeyance, till completion of a review of the eligibility of the employees concerned to receive to receive the same. So, the petitioner being aggrieved with the keeping in abeyance of the benefits under the said scheme, submitted representations before the respondent authorities. The said representations of a response. The petitioner instituted a petition before this court being WPC number 4897/20. A coordinate bench of this court-wide order dated 13/9/2020, noticing that a review was contemplated in the matter, proceeded to dispose of this, directing the Director of Technical Education to conduct whatever review as may be advised within a period of 1 month from the date of receipt of a certified copy, and to pass a final order on the entitlement of the petitioner for MACP benefits. The respondent authorities thereafter proceeded with the review, and upon considering the matter in its second meeting held on 30/9/2023, proceeded to arrive at a conclusion that the services of the petitioner being regularized only with effect from 30/12/2016, wide issuance of an order dated 2/1/2018, he had not completed the mandated 10 years of continuous service as a government servant for being entitled to be extended for being granted the first financial upgradation under the said MACPS scheme. So, accordingly, the MACP first financial upgradation benefit as granted to the petitioner, while the order dated 29/9/2021 came to be cancelled. So, being aggrieved, the petitioner has instituted the present petition. Mr. D. Borua, the learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the initial appointment of the petitioner on compassionate grounds against a grade 4 post in Jorhat Science College was an appointment so effected basing on compassionate grounds. He submits that the said appointment of the petitioner had the approval of the state level committee. He further submits that on the date when the petitioner was so appointed in the Jorhat Science College, the same was a government college, and accordingly the petitioner on his such appointment is to be deemed to have been a government servant. Mr. Dotto submits that for all intent and purpose, for the purpose of reckoning the period requisite for grant of first financial upgradation under the MSAPS scheme to the the date of his initial appointment against a grade 4 post in Jorhat Science College would be mandated to be so considered. Next. Mr. Borua submits that after the Jorhat Science College was merged with the Jorhat Institute of Science and Technology, and the services of the petitioner was also placed along with the post held by him under the control of the Jorhat Institute of Judge under the control of just, the petitioner continued therein as before with the same service conditions. It is submitted that the just at the relevant point of time was managed by a society constituted in the matter by the government. Also, he submits that with the issuance of the notification dated 30/12/2016, just having been brought under the governmental control, under the control of the Government of Assam, Higher Education Technical Department, the status of a government servant, which was attached to the government, to the petitioner on his initial appointment on compassionate grounds in Jorhat Science College stood revived. Accordingly, he submits that the petitioner on being again brought under the government, being brought under the government service, the period with effect from the date of his initial appointment in Jorhat Science College would be deemed to be service rendered under the government. Also, Mr. Borua submits that reckoning the said position, the respondent authorities next had rightly authorized to the petitioner his first financial upgradation under the MSCPS scheme by issuance of the notification, by issuance of an order dated 27/9/21 or 2022?
Which one, Lordship?
The first financial upgradation given to you?
I was given by
22. Right?
what?
Also, Mr. Borua submits that on a misinterpretation of the provisions
23/9.
as well as the service conditions attached, service conditions of the governing the petitioner's service, the first financial upgradation as granted to him under the MSCPS scheme came to be kept in abeyance while the order dated 18/1/2020. He submits that the respondent authorities are reviewed by reckoning the regularization effected in respect of the petitions with effect from 30/12/2000 wide and order dated 2/1/2018, proceeded to hold that with effect from 30/12/2016, the petitioner not having completed 10 years of service under the government, he was not entitled to be extended with the first financial upgradation benefit under the MSCPS scheme notified by the notification dated 6/7/2017. Mr. Burwa submits that although the petitioner was submits that it is a settled position of law that an appointment under compassionate grounds cannot be made against a temporary and or cannot be made on temporary and or ad hoc basis, and such appointment, if made, must be so made against a against a regular sanctioned vacant post. Accordingly, Mr. Burwa submits that the initial appointment of the petitioner so affected on compassionate grounds must be deemed to have been so affected against a valid sanction post. Mr. Burwa further submits that in the event there existed any irregularity in the initial appointment of the petitioner, they said irregularity was remedied by the regularization of his services effected by the notification dated 2/1/2018. However, he submits that such regularization would now have to relate back to 10/3/2010 when the petitioner was initially appointed on compassionate grounds. Also, in the above premises, Mr. Burwa submits that construing the period, reckoning the period requisite for being granted the first financial upgradation in terms to the petitioner in terms of the MSCPS scheme notified by the notification dated 6/7/2017, on the date the petitioner the petitioner had completed more than 10 years of service as on 27/9/2022 when he was so extended with the first financial upgradation benefit under the said scheme. Mr. Burwa accordingly submits that the order dated 18/1/2023 and the order dated 11/10/2023 would mandate an interference from. Next. Per contra, Mr. S. Das, Learned Counsel, appearing for the Learned Standing Counsel, Higher Education Department, appearing for the state respondents, has submitted that it is an admitted position that the petitioner, along with 4 other employees of GIST, were allowed the first financial upgradation under the said MSCPS wide an order dated 23/9/2022. He, however, submits that the said grant was with the further stipulation that in the event any error/shortcoming is so detected in future, the said benefit would be permissible to be so revoked. Mr. Das has submitted that the scheme, the MSCPS scheme mandates rendering of 10 years of regular service for being granted. Mandates an employee to have rendered 10 years of regular service to be extended with the first financial upgradation benefits under the scheme. It is submitted that the petitioner's services were regularized only with effect from 30/12/2016. Accordingly, as on 23/9/2022, when he was granted the first financial upgradation benefits, the petitioner cannot be held to have completed 10 years of regular service. Also, it is submitted that on a review being made of the eligibility of the petitioner to receive his first financial upgradation benefit under the MSCPS scheme, it having been found that the petitioner had not acquired the requisite eligibility criteria, having not satisfied the requisite eligibility criteria for the same, the first financial benefit, upgradation benefit as granted to the petitioner came to be cancelled void order dated 11/10/2023 after it was kept in abeyance void the order dated 18/1/2020. Also, in the above premises, Mr. Das submits that the petitioner hearing would be entitled to receive his first financial upgradation benefits on completion of 10 years of service with effect from 30/12/2016 only. And accordingly, the impugned or the order dated 11/10/2023 impugned in the present petition would not mandate an interference from this court. I think it has covered both of you. I have heard it. Anything more?
No, I submit that the regulation order, he did not challenge before coming to this.
Mr. Das has further submitted that in the above premises submitted that the regularization order dated 2/1/2018 being not put to challenge by the petitioner, the same would continue to hold the field and the petitioner can be deemed to have become a government servant only with effect from 30/12/2016 and not from a date prior thereto, right?
Right.
I've heard the learned counsel for the parties and also perused the materials available on record. The issue arising in the present proceeding is as to whether the petitioner hearing would be entitled to reckon the period of service rendered by him with effect from 10/3/2010, that is the date on which he was appointed on compassionate grounds for the purpose of determining his eligibility for being granted his first financial upgradation benefit under the provisions of the MSCPS scheme notified via the notification dated 6/7/2017. Also, as noticed here in above, next time, the petition was directed by the government in the education bracket higher department to be appointed against a grade 4 post existing in the Gauhati Science College after his case for such appointment on compassionate grounds was approved by the state level committee. It is a settled position of law that appointments on compassionate grounds have to be mandatorily effected on a regular against a regular sanctioned vacant post. The claim of a person for appointment on compassionate grounds can either be rejected or be accepted as per law, and once it is accepted, the appointment is to be understood to have been so made against a regular vacant sanctioned post. Considering the said position, this court would have to hold that the initial appointment of the petitioner on compassionate grounds effected by the order dated 10/3/2010 is an appointment on regular basis. The parties to the proceeding have not the respondent authorities have not disputed that on the date when the petitioner was appointed on compassionate grounds against a grade 4 post in Gauhati Science College, the said college was not under the government. Rather, it is on record that the said college at the relevant point of time was a government college. Also, after the joining of the petitioner against the post of grade 4 in Gauhati Science College, the Jorhat Science College, the employees working in Jorhat Science College were transferred to Jorhat Institute of Science and Technology, just along with the posts held by them in Jorhat Science College. The notification dated 9/6/2010 issued in this connection also stipulates that such transfer is without prejudice to the existing service conditions. In other words, the status of a government servant continued to be attached to the employees of Jorhat Science College on their transfer to GIST, and accordingly, the petitioner is to be held to have carried the status of a government servant during the period he had served at GIST. Next, the respondent authorities, via notification dated 30/12/2016, proceeded to declare that the administrative control of GIST was being bought under the Government of Assam, Higher Education Technical Department with immediate effect. It was further stipulated in the said notification that the Jorhat GIST would come under the category of a full-fledged government engineering college. Accordingly, the services of the petitioner was again brought and placed under the government, and accordingly, he, for all intent and purpose, again continued to be a government servant. Also, the respondents thereafter, via an order dated 2/1/2018, proceeded to regularize the services of the petitioner and five others, with effect from 5 others who were at the relevant point of time serving against various posts in GIST, with effect from 30/12/2016. It is not projected that other than the petitioner, the other appointees were also so appointed on compassionate basis.
Others are not compensable.
It is not, that's what I'm saying. Also appointed on compassionate grounds. So it is the petitioner who was initially appointed on compassionate grounds. As noticed herein above, an appointment on compassionate grounds, when effected, can be so effected only against a regular sanctioned vacant post, and such appointment has to be so made on a regular basis. Also, to give a meaning to the regularization effected by the said communication dated 2/1/2018 of the services of the petitioner with effect from 30/12/2016, this court holds that the same would only be for the purpose of regularization of any infirmity that may have crept in while affecting the initial appointment of the petitioner against a grade 4 post in Jorhat Science College, wide the order dated 10/3/2010. Accordingly, for all intent and purpose, the said regularization, insofar as the services of the petitioner is concerned, could not have been limited back till only 30/12/2016, and the same must be construed to relate back to the initial date of appointment of the petitioner, on compassionate grounds effected wide order dated 10/3/2010. Accordingly, the petitioner is held to be a government servant with effect from 10/3/2010. First off, applying the set, having drawn the set conclusion, this court finds that the petitioner being now rendering his services as a government servant with effect from 10/3/2010 had completed 10 years of service, regular service under the government, and accordingly, his case is covered by the provisions of the MACP scheme, notified by the notification dated 6/7/2017 for being extended with the first financial upgradation under the said scheme on completion of 10 years. Also, accordingly, the grant of first financial upgradation to the petitioner, void the communication dated 27/9/2020 is found to be not erroneous. Also, this court would now consider the order dated 11/10/2023 impugned in the present writ petition. The said order being relevant is extracted here, page 33A to A. A perusal of the said order would reveal that the review committee as constituted in the matter had held the petitioner to be not eligible for being extended with the benefits under the first financial benefits of the first financial upgradation under the MACPS scheme only by noting that the petitioner's services were regularized by the order dated 2/1/2018 with effect from 30/12/2016. Accordingly, the committee proceeded accordingly by the said order, basing on the recommendation of the said committee that the petitioner was not eligible for being granted the first financial upgradation benefit under the MACPS scheme, proceeded to cancel the grant of such benefit to the petitioner via the communication dated 29/2022. Also, this court having already concluded herein that the petitioner's regular service for the purpose of MACPS being required to be so reckoned with effect from 10/3/2010, the petitioner being found to have completed 10 years as of 29/2022, the cancellation of the benefits already granted, first financial upgrade granted to the petitioner be erroneous. Also, accordingly, the order dated 11/10/2023, insofar as it concerns the petition, stands set aside. Also, in view of this court having interfered with the order dated 11/10/2023, the order dated 11/10/2023 having been interfered, this court directs the respondent authorities, more particularly the Director of Technical Education, Assam, to extend to the petitioner the benefit of first financial upgradation under the modified assured career progression scheme, notified by the notification dated 6/7/2017 with effect from a date on which he has completed 10 years of service by reckoning his such service with effect from 10/3/2010. Consequential orders authorizing to the petitioner his first financial upgradation benefit be issued by the respondent authorities within a period of 2 months from the date of receipt of a certified copy of this order. It is provided that in the event any financial benefit, obligation benefit has already been drawn by the petitioner in terms of the earlier order, the earlier grant to him of such benefit by the communication dated 29/2021, the same shall be deducted and the areas thereof be released to the petitioner within the time frame so prescribed herein above. With the above observations and directions, the present petition stands disposed of. Anything more? You appoint people on compassionate council, keep them in doldrums.
Principal of the college.
That principle might be gone now. Can't.
This also.
Yeah, that to me is only. Three. Yes, Mr.
Get two notes. If Lordship allow, I want to submit.
Oh.
It will be probably give assistance to Lordship.
This court is that old 786 computer, not a present microchip like you.
Lordship.
You give me something, it takes time for me to appreciate. KL,
Lordship.
we have changed the.
No, Lordship, this is the picture, real picture that will be demonstrated before Lordship.
But I also, my research came to. But the thing here is, the distinguishing factor here is that you, in other cases, they had not adopted the central civil service pension rule. You had adopted that.
It's probably initially what happened in 2023, we received a notification.
No. I'm beyond that. There is a who have brought it, or Mr. Goswami has brought it.
Page 210.
Huh?
Page 210.
Ima?
210.
210. You come to 210.
Lordship.
This is with regard to the scales of pay. Item number 38. This is your first meeting of the Executive Council. If you come to page 213, that is important. The council decided to follow the central government orders and manuals, rules and regulations to decide the service conditions and entitlements of the employees and to manage the day-to-day affairs of the university till such time the university is able to prescribe its own. The university never prescribed its own. So in your university, persons who were there prior to 1/1/2004 are all covered by central pension rules.
Yes,
So this is not a case that the 87, one of the cases that you have referred here is the 87 circular of the government, which says that if you are there, you can adopt
Yes.
the central CPF to GPF.
GPF.
You can do that.
Yes, Lordship.
Here it is not required. Now what has happened? Correct me if I am wrong. The government of India notified the new pension scheme sometime in November 2003. It comes to you. There is no adoption here.
Yes, there is no doubt.
No adoption. You apply it automatically. Because it is a decision of the government, you apply it automatically. Once you apply it automatically, all the employees who have come into your service of the university after 1/1/2004, you apply NPS.
NPS.
Now in this central government, what happens is that the central government takes a decision, 17/12/2020, that, okay, wherever the selection process is complete prior to 31/12/2003, we are giving the OPS scheme, even if the appointment is after 1/4/24. This was contested all over the country.
Yes, Lordship.
In Delhi also. In Delhi, it was said that no, it cannot be, because the ratio, the analogy taken was that when you advertise this post, the post concerned, the service condition prevailing on that day will be
applicable.
right? So bringing that analogy, the Delhi High Court and various, even our High Court, CAT, all passed directions.
Yes, Lordship. That is
So this went to the government. Now the government then said, okay, done. What has happened has happened. Wherever advertisement, now this is a big come down. From 1720 to coming down to this, it's a big come down. Then it said, wherever advertisements have been issued prior to 31/12/2003,
then they will
whenever you appoint, you will be.
But by.
Now tell me one thing. If you say that you are an autonomous institution, you're not covered by any decisions of the government other than the CCS rules, because you have adopted it. Then how could you apply the NPS scheme without an adoption to the employees? Because your objection and the UGC objection is only to the extent that in 2020 notification, that word government employee is used. Even in the NPS notification, you will find the word used is government employee. So, it is a case, Mr. Goswami has fairly not argued to that level. It's a case wherein NPS cannot be applied.
What happened here? We are bound by the circular of the UGC.
UGC made a blunder here.
Yes, Lordship. Lordship, that's why
And the council at least had made a very fair submission
Lordship.
that they are all government servants. I had to highlight to him that you are making a submission beyond your pleadings. I don't want to put him to trouble.
That is there not case also, Lord.
That is not the case, but he was making a contrary submission.
Lordship, page 217 of affidavit filed by my learned friend, Lordship. And this is fact, Lordship. We are not denying this.
No. Mr. Kayal, of all cases of Assam University that had come to me, this is one case wherein I find that the university was very up and going to favor or to extend the due benefits to its employees.
Lordship, earlier also some.
The other cases, maybe I have some reservation, but this case is a very good case to that part.
No, this is my submission, Lordship. And in affidavit, we have explained why.
Your affidavit is only nothing of yours, but the 213, 213, this is your already adopted thing. Now, if I ask you, why did you apply? Your reply would be item number 39, because we had adopted a resolution, a decision, policy decision, that whatever the central government says will be coming here. Now, if NPS has come, the clarifications to NPS will also come.
The clarification is that whatever Lordship said, that since 1/4/2000, 1/1/2004, before that Lordship, they will be.
You have the NPS notification,
That
2003. You have it, Mr.
That notification is not clear. Sorry.
2012-2003.
Is there?
That is 2012-2000.
Oh, 2003. 2011-2003 or 2012-2000.
2012.
12. You have it?
That's what I've been giving just.
For new entrants to central government service. So, in all probability, this should not have even been applied. Anyway, you have given me a perspective. Thanks for that. I'll have to do some more research now.
Lots.
It's given me 2 pages thing. I'll do that. But my logic is this.
No, Lordship,
I have not found a decision applying squarely on this point.
I have also didn't.
The decisions that you have relied, some of them I have also come across. It is with regard when there is CPF scheme.
CPF.
They wanted the central civil service pension rules to be applied. Both said no.
No. There is
But there are decisions of the Supreme Court also with regard to that 87 NIT, National Institute of Technology. Therein it was CPF scheme. Under the 87 notification, they shifted to the GPF scheme. That was upheld by even by this court and by the Supreme Court.
And our appointment letter says we are entitled for GPF. Page 57.
50?
57. All appointment says, that's it. You will be entitled to GPF come gratuity GPF as per university rules.
No, that is oblique CPF.
Oblique.
Whichever is applicable.
That's it. GPF?
CPF, GPF both gone. Now it is contribution. And what about the unified pension scheme? That has not been applied.
That is not yet.
The but Mr. S.K. Goswami for the petition, but Mr. S.C. Kal, Learned Senior Counsel, Standing Counsel, Assam University, assisted by Ms. P. Upadhyay, Learned Counsel for the respondents number 6 and 7. The matter was listed today for delivery of orders. However, Kal has basing on the instructions received as well as on the research made, placed on record 2 notes for assisting this court in disposal of the present. Copies of the said notes have also been handed over to Mr. S.K. Goswami, Learned Counsel for the petition. So, this court would now be required to also factor in the contentions raised in the said notes. Accordingly, the delivery of order today is deferred and the registry is direct. This matter again, up free 19/6/2026 for delivery of orders.
Much.
Nothing more. Mr. Goswami, ask your colleagues to do some research on this. And I could not go. I went to a certain level. Beyond that, I could not go. By this logic, what I was planning, for that I got materials. I was about to go with that. Let them, either way, be fair. Now, Supreme Court has also said it's not the decisions on your favor. Decisions against you also should be put forward. It's for the court. Get something. As an officer of this court, please assist me. 19th ki bar hai? Ah, Boria. You can give it to me by 17th. Anything is there. Not touching this before, sir. Yeah. Yes.
It is not our employee of Kolaket, Simoto Sankodev Kolaket. They brought into under regular pay scale of 2018 mileage. There is LICI group insurance provision mileage. 16 numbers of similarly situated person has included already, my lord. Annexer, my lord, B, page 29. '29, 31, and 32, my lord.
20?
29, my lord.
You have retired or you are working?
Working, my lord.
Yes. Mr. Goswami?
Some instruction received, Lordship.
I considered this matter once, I suppose.
Due to untimely demise of petitioner number 2 and 15, if encashment has been issued.
Only leave encashment given.
Only. Our pair is that, my lord.
Leave encashment employee.
You all are regular employees?
Regular, my lord.
Please for, yeah, Mr. Sharma.
Regular.
I am for respondent 2 and 4, Lordship.
That is the Kolakshetra.
Yes, yes.
Huh.
There is some proposal for giving the, in a meeting of advisory conference, we have decided to give them the gratuity also. Lordship. They will be paid.
No, for that you will have to bring them within that LIC thing.
Yes, Lordship, it has been done, Lordship.
It has been done.
Yes.
File an affidavit.
Yes, Lordship, we shall file affidavit, it shall bring a required affidavit, Lordship.
If that is done, they're done. Why should we go in? Because these are policy matters. But at the same time, you cannot discriminate between two sets of them.
No, there is no sense of discrimination, Lordship. It's a...
Okay. Let him
Fine.
file an affidavit. But Mr. Borua, learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned counsel, learned additional senior government for the state respondents, and Mr. R. Sharma, learned counsel appearing for the respondent number 2 and 4. Mr. Sharma submits that the respondents number 2 and 4 have further processed the matter and resolutions have been adopted for grant to the petitioners the benefits as prayed for by them to the extent of payment to them of gratuity.
Pensionary benefit, gratuity, and leave encashment.
Pensionary word is not there.
Gratuity. He submits that the petitioners on their superannuation would also be entitled to leave encashment benefit. He submits that he would file an affidavit to bring on record the the developments taking place subsequent to the institution of the proceedings. The present is subsequent to the filing of the affidavit in the present petition by the respondent number 2 and 4. How long?
3 weeks. And it should be. And some translation work is there.
Oh, you give the original of the
After 2 weeks, my lord.
you give the vernacular, we will see. Kalakshetra people, their handwriting will be very good. We can read.
It is typewritten.
Then so what is the problem?
Vernacular, it will not accept to the register filing. It will not. Filing section, it will not. Affidavit will not accept it.
How many pages are? 2, 3 pages. Mr. Sharma,
Now the AI
you give it to
procedure-
me, I'll dictate it here, Lina.
No, no, AI makes easy loads.
AI.
Yes.
Very dangerous.
Very,
AI translation is
very,
very
no,
dangerous.
no, but very easy
No,
loads.
no, no, don't do AI translation. Do it freehand translation. You have the copies with you.
No, it is in my mobile phone also.
To list this matter, Aji ki man tarikh?
29.
On 22/6/2026, the affidavit be invariably filed by the respondent number 2 and 4 on or before the next date of list. We'll see, Mr. See what happens.
The petition is going for my AI.
But in this matter, we were to file an affidavit, my lord, which we have filed today itself, my lord. Let this matter come up next week, my lord.
You are appearing for?
Yes, ASIDC, my lord.
Says thus, learned counsel for the ASIDC. That is the respondent's number 4, 5 of 3, all.
Yes.
3, 4, 5, 6, 7.
3 to
and
6.
8.
3 to
3 to 8.
8.
Submits that an affidavit on behalf of the respondents represented by him would be brought on record. Additional affidavit.
Additional affidavit.
Additional affidavit would be brought on record when?
But today we have filed, my lord. Next week.
Today.
Yes, today we have filed.
Affidavit has been filed today. So, petitioner is granted a week's time to file a rejoinder thereto, ipso advised. Registry to list this matter again on
2nd week of June, my lord. Any date.
Before 20, my lord.
Hmm?
Before 20, my lord.
Before?
20 June.
Before 20 June. Okay. On 15/6/20.
15, my lord. Highly obvious.
Yes.
Lordship, in this case, Forest Department was supposed to produce record.
Now forget producing records. The forest itself is vanished. Huh?
Challenges to the
Have
discipline.
you threatened Mr. Purkhaisto that if you come into the court, we will
So
see?
he was
if there's
there. He
something?
was there in the first half.
Oh.
Someone is there in the first half.
It is the fault of the court. The court was slow today.
Lordship has disposed of many matters we have seen today. We have challenged the punishment and discipline.
And Mr. SD Purkhaisto, SD Purkhaisto, for the petitioner. There is no representation on behalf of the respondents. For the ends of justice, the matter stands adjourned. The respondents are directed to produce the relevant records invariably on the next date of list. Registry to list this matter again on Fundina Pari. 7/6/2026.
Published.
It online as well. Today was online. Why are you all here? The very purpose is
I
being
stay nearby,
defeated.
Lordship. I come on foot every day.
No. This purpose is defeated. It's a very tough situation. It's for national interest that was done. So at least.
I come on foot, Lordship. And every day I come by and stay nearby, I come on foot. So there is no fuel consumption. Obliged.
So you mean to say that the judges also should come on foot now? No, it's a It's something which is for all of us.
Yes, yes, all of us.
So maximum, I forgot that it was Friday today. Maximum adherence to that would be good. Okay.
Obliged.
Okay, we have to rise now. Any urgent matter?
No, order 49. Date me kindly fix.
Item?
49. It was
On the prayer of Mr. A. Roshik, learned counsel for the petitioner, raised it to list this matter again on
8, you know, 8.
15/6/2026.
Your Lordship, item 39, Your Lordship. Simple matter. Can it be any day or the next week?
What is the issue?
Issue is renewal of arm license.
That case.
Yes. Section 17.
They have filed an affidavit.
Nothing.
No, nothing has been filed.
Instruction was that whether any action has been taken under section 17. If not, renewal automatically under section 15(3).
A date of the DD, 39. Yes.
Yes.
Made.
Lordship,
Which item?
46, Lordship. Only interim to continue, Lordship.
Heard Mr. D. Ulla, learned counsel for the petitioner. Affidavit filed?
They have not filed the objection, Lordship.
The respondents have yet to file their counter in the matter. Accordingly, registry to list this matter after 3 weeks. The respondent shall invariably bring on record their stand by way of filing an affidavit before the next date of the interim order passed earlier to continue till the next date of the.
Obliged.
My lord, item number 40, my lord.
Ah.
My lord, matter may be taken up next Thursday, my lord.
What is the issue?
My lord, allotment of work, my lord. Contractual, my lord. Contractual work, my lord. Tendering, my lord. Petitioner was alone, my lord. Subsequently, my lord, they have cancelled. That is the ST is there, my lord. Yes, my lord. And pleading is also completed.
On the prayer of Mr. S. Hawk, learned counsel.
Next Thursday, my lord.
Registry to list this matter, Pari?
Thursday.
9/6.
Lordship, item number 37.
Yes, I'm coming.
If any-
9/7. Interim order to continue?
Yes, my lord.
Interim order passed earlier to continue till the next date. Yes, Mr. Shaw.
Item 36, Your Lordship. I have filed the additional affidavit.
On the prayer of the learned counsel for petitioner in person. Heard the for petitioner in person. So, registry to list this matter. When do you want it?
Next week, Your Lordship.
Next
So
week
9
is
or
tied
10
up.
or June.
Next week is tied up. Thereafter, I can give you on 12th. 12/6.
I beg to mention item 33. Any date, a date may be fixed in this matter.
On the prayer of the learned counsel for the parties, registry to list this matter again on 11/6. Come on, 11/6/2026. Rest.
My lord,
Yes.
my lord, item number 32, my lord, a date may be fixed, my lord, if possible. 32.
The prayer of the learned counsel for the parties, date 30. Yes, Mr. Loskor. Mr. Loskor. MH Loskor, yeah.
Lordship, item 37, any date may be given. Lordship, item 37, any date may be given.
On the late, any interim order? No.
No, Your Lordship. No.
Mr. Goswami, any interim order?
No, my lord. No, my lord.
37, na? 37 as paper date 30.
48, a date may be given.
He shall give it to you, don't worry.
Obliged.
Really bad. আর যদি interim order আছে কবার I will be able. Yes.
Item 38, a date may be given.
38.
Lordship. It's regarding renewal of the arms of license.
Oh, that.
Yes.
There's another.
Let's have filed the affidavit.
আর মজুমদাৰৰ কেছ এটা আছিল নহয় 39. 39 যোনদিনা দিছ 89 দিলে. Nothing. The government has nothing. No stakes.
In absence of petitioner, my lord.
Oh, fair.